Or your side mentioning?
Kindly
Wait, Mr. Sinha. Yes.
Lord, may I have my lords kindly to mention an arbitration petition which was returnable on the 11th of September. We could not participate in the proceedings in light of the resolution. Lord, Lordship had directed and observed in the court on 30th of August 2023 that notes be exchanged between the parties in light of the judgments that we had cited. We have prepared that. My lord,
Which one is this?
my lord, this is Funtail Enterprise. This is
No,
pertaining.
no, no. I don't remember matters by
I will
names.
indicate, my lord. This was
give me the
pertaining
law
to the
form.
license
That's-
agreement. The respondent had indicated that it was a lease agreement. It's our contention.
So
it's a
what do you
license
want? You want inclusion in the list?
Well, it is returnable on the 20th, my lord. Can it be on the 21st, my lord? I'm mentioning upon notice. Two
Very well.
matters.
Where it will be in the list on 20th. If it is, just ask somebody to mention, I will put it
Very
on
well.
21st and remind me that you
I'll
will
also
mention.
give them the notes. I'm
Let I will permit you to mention one matter to which your lordship has been pleased to pass an order of warrant of arrest to the managing director of the judgment debtor. This is in connection with the execution matter. In spite of several occasions, they could not appear before your lordship.
Yes, yes. What is it that you want?
My lord, let it appear in the list tomorrow.
Tomorrow?
Tomorrow.
No, it will appear in the list on the day it is supposed to appear in the
My
list.
lord, there is, my lord, what happened, my lord? They
No,
filed
this is not the time for arguments. Sorry. Yes. No, no. Who else is there? Yes, yes. You.
With your lordships kindly mentioning that for inclusion in the list, lordship in a section 36 application, your lordship directed us to deposit the award amount, lordship. Lordship, we could not file the deposit within time, lordship. There is a delay of 2 weeks, lordship. We have filed an application for extension of time, lordship. That is pending, lordship. That's not in the list, lordship. May kindly.
No, you filed the application.
Lordship, we have filed, lordship. That is not coming in the list, lordship. We filed
have
on
filed?
18th August, lordship. We have.
Okay, Ashwin, I understand. When did you file?
Lordship, 18th August, lordship.
18th August.
Yes, lordship.
And you're mentioning after exactly a month.
Lordship, we tried, we thought
No,
that
no,
lordship will be in the list, lordship.
Mentioning will not be. It will
Lordship,
be
that time your lordship was not.
Wait. If you are filed, it will be in the list, all right? I personally look after my list every evening and in the morning, so don't say these things. Yes, there is absolutely no hanky-panky in my court. Yes, yes, Mr. Sinha.
Let us bring from Allah's to mention 3 execution matters which have been settled between the parties. Let us bring for leave to withdraw. Let's put the matter appears to be mentioned, not any day conveyed, your lordship.
Yes, to him, what, it's
Execution section 36.
no, of which year?
2021.
21 এ কতদিন লাগবে তোমাদের বার করতে কাগজ? কালকে দেবে না পরশু? Yes, on Wednesday.
I'm good.
Notice to the other side, please.
I'm good.
May I have the lordships kindly to mention item number 230 of your lordship's list, my lord. My lord, this is an execution application. I was praying for upgradation. Money is deposited in this court, my lord.
You're the.
I am the petitioner, my lord,
No,
the
no, no.
award holder.
So you want to withdraw the money?
I would pray for an order withdrawing that money, my lord. That would satisfy the award in a large part, my lord.
So have you not, there's an application to that effect,
Item number
or
230 of the monthly list of your lordship, my lord. If it can be upgraded, my lord.
it's not a new chamber?
It's a new chamber, my
It's a
lord,
new
appearing
chamber.
for the first time.
Very well. এটা কি এখন কি সম্বুধ শুক্র হচ্ছে নাকি? Yes, yes. It will be in the list, not if upgrade করে দাও on 21st.
Grateful.
And if it is not taken up, you mention on the following Monday.
Great.
Yes, Mr. Jaina.
I have filed an application under section 34 challenging the award of MSAB Council. I had not deposited 75% amount.
You have not.
Not, but subsequently your lordship has granted leave to deposit that amount within a particular.
I can't hear you. Microphone, please.
Well, your lordship directed us to deposit that 75% amount within a time. I have deposited that amount. My lordship also directed after depositing. You
So what is
mentioned
it that you want?
34 application be listed for hearing.
The 34 application.
34
And it's of which year?
This is my 2023.
23. When did you deposit the 75%?
75% before the register pursuant to your lordship direction.
When did you do it?
My lord, I deposited on 8th September 2023.
Yes, you have to wait till the 2nd week of October. Mention in the first week, we shall list it. Yes,
May I have my words? Your lordship
I
directed us-
can't hear
Your
you.
lordship director has deposit, mentioned next week after depositing.
Yes, mention in the first week of October. Yes,
May I have my lord's leave to mention an admiralty suit for withdrawal, my lord.
of which year?
Of 2021, my lord, I am mentioning about notice, my lord.
Yes, এটাকে next, দেখো Wednesday, Thursday হবে কিনা?
I am obliged.
You can't understand that you have to use the microphone.
As per your lordship direction, my lord, I have mentioned this matter on 3rd week of September, my lord. And upon mentioning to the other side, my lord, here the register, on the last occasion, my lord, the Honorable Justice Shekhar Vishal have directed the register to inform the court about the amount deposited by the award debtor, my lord. The amount has already been deposited.
What is it that you want?
My lord, kindly to hear the matter any day before vacation, my lord.
Last taken up on when?
Last taken up on 27th April of 2023, my lord. Huge amount has been invested, my lord. by the-
You're the award holder or
Yes, my
debtor?
lord. Award holder, my lord.
Award holder, it's a
Yes.
34,
Yes, my lord, 34.
34.
Yes,
And there's a stay of the award.
my lord, actually this is the execution.
It's a point of law. Please hurry up and answer the question. You should know whether the
Yes,
award is
there's a
stayed or
stay of
not,
the award.
not before the 2nd week of October. Yes, Mr. Mukherjee.
My lord, section 34, I am the respondent. Section 34 of 2022, there was direction for affidavits. I'm out of time. I'm only praying, my lord, if the matter can be listed any day convenient.
You're
so that
the
my
award
affidavit- I'm-
holder.
This, my lord, there's, both parties have filed a 34. in this
Yes.
matter, my lord. Only, my lord, matter to be listed any
Direction
day
dated?
convenient. Direction is of 2022. I'm out of time in filing my affidavit in opposition. So, my lord,
You
I'm
wait
ready
till
with my
24,
affidavit.
then you'll get some more time.
My lord, your lordship will list it any day convenient, my lord. And then, my lord, your lordship will decide if my affidavit can be accepted.
Yes,
The other side has also filed a 34.
yes, on 10th October.
May I have your lordship's kind
And
to,
please notice to the other side.
yes, ma'am. I have your lordship's kindly to mention one section 9 application, my lord, section 9 of the Arbitration and Conciliation Act, my lord. Here, my lord, a preliminary objection was taken by the respondents that the arbitral tribunal had been considered and the section 9 application cannot be heard by this court anymore. My lord, your lordship, by an order dated 20th July, had directed that substantial hearing has been done and this honorable court has applied its mind. Therefore, it will not act as a fetter to this honorable court to hear the section 9 application and had given us liberty.
So it was a order on 9/3.
Yes, my lord.
It was an
Yes.
order on
Order
9/3.
under 9/3, my lord, and had given us liberty to mention the matter for expeditious hearing. Thereafter, on 31st July, my lord, we had mentioned before your lordship, and your lordship had directed the matter to be fixed on 16th August. However, my lord, due to the circuit bench being in session, my lord, the matter could not be
I've
listed.
been in Calcutta 4 weeks after the circuit bench.
It could not be mentioned thereafter, my lord. I was only praying if your lordship could, my lord, kindly, my lord, keeps the matter any day convenient to your lordship.
2nd week of October.
I'm deeply obliged, my lord.
My lord, two matters,
Yes.
execution application, my lord, for upgradation. Lord, I gave notice that matter would be mentioned on 14th, but since my lord, your lordship did not may I mention today, my lord. My lord, in both the cases, my lord, in one case, MSME award my lord, amount is 69 lakhs, my lord. And my lord, section 34 application filed, but I filed pre-deposit application. My application was allowed, my lord, but despite direction and my lord,
I don't understand. You're the buyer or the seller?
I'm award holder, my lord.
Award holder.
My lord.
So you're the seller,
Yes, my lord.
supplier.
Yes, my lord.
Yes.
My lord, by the last order, my lord, it was directed that it deposited not made by 10,
What is it that you want?
my lord, upgradation. My matter is in the list, my lord, and my lord,
Maybe. Why upgrade?
my lord, facing acute financial hardship. My lord,
You're the
by,
MSME.
I'm my lord, yes, MSME award, my lord.
Are you the MSME? You can't understand what the court is asking you. Are you the MSME?
My lord,
Come back with facts. Yes. Yes.
May I have a kind leave to mention the company matter, the Dunlop India matter. Your
Yes.
lordship, my application was heard on 21st of April last. And thereafter the matter is running in the list and the monthly list is item 31 and 32, even on today.
You are appearing for who?
I'm appearing for Salazar
No,
against
no,
Dunlop.
don't say Salazar. Who is Salazar?
Your lordship, there is a property which was put for auctioning and we were the 50% owners. We are the 50% owner. So we made out an application where your lordship heard the matter. The other side didn't represent on the last day,
Last heard on?
21st of April, your lordship. And we have been mentioning.
You've been
twice.
mentioning
We've
what?
mentioned twice, your lordship.
Yes, on,
Is
it's a new chamber or, it's those, very well, specially assigned matters.
Yes, your lordship.
Yes, on, 12th October, notice to
Sir,
the
may I
others.
be permitted to mention one review application, my lord, in this matter? My lord had heard us on that article 215 issue, my lord. My lord had declared that the review was maintainable, my lord. But I'm mentioning it for hearing of the.
Article 215 issue,
Yes, my lord,
that
regarding
the Superior Court has power.
yes, my lord, that one, my lord, the review application I'm mentioning for inclusion, my lord.
Yes, on 9th, notice to the other side, please.
Grateful, my lord.
Lordship, to section 11 application of 2023, Lordship, these two matters mistakenly filed in regular division, which should have been filed in commercial division. All formalities has been completed. I'm praying for inclusion in the list.
When did you file the matters?
I filed in the matter in 28th of July, 2023.
And when did you realize the mistake?
Lordship, the matter has appeared on 9th of August, 2023, and we submitted this fact before your Lordship, and there was a direction by your Lordship.
Yes, 11th October.
Lordship,
Yes.
My lords, kindly to mention the matter, my lord. This is item 31 of my lord's ordinary list, the square four matter, my lord. It was last taken up on 31st August. And on the last day, the respondents had completed their submissions. It's appearing as item 31 today, my lord. I was humbly praying if it could be listed higher up on any day, subject to my lords.
Very well. It asked now call me to
May I
Yes.
have your lordship leave to mention a section 36 application? My lord, it's item number 236 of your lordship's monthly list, my lord. It's appearing, it will be taken
I
up.
can't hear, you can't understand that? Yes.
My lord, section 36 application, it's item number 236 of your lordship's monthly list, my lord. It
Yes.
will be taken up for the first time. My lord, it was filed on 11th of August 2023, and thereafter it has gone to monthly list, my lord. So
You're the award debtor,
I am the award holder, my lord.
section 36.
Section 36.
Then why you
Execution
mention-
application.
Execution, say that. 36 is usually for stay under 2. Yes, second week of October. Yes.
May I be permitted to mention one section 9 application? My lord, it was filed in a non-commercial bench, but it should be filed in a commercial dispute. And that's why Honorable Justice Saraf delisted from 24th April and directed that to department to file 1 week after 24th April. But it was not came in the list. It's a new motion, my lord, under section
New
8.
motion.
New
What do you
motion. It is a totally new, my lord, last location.
I can't understand what you're saying. What is it that you want?
My lord, this is a new motion under section 9. It was filed in a non-commercial dispute, but it should be inadvertent.
Section 9 comes under the heading new motion.
And it's a new motion, my lord. It is the last order of Honorable Justice Saraf. And that's why
Don't show any documents, please. No documents on mentioning. Yes, what is it that you want?
it is the new motion
Yes,
under section 9.
third week of October. Yes.
Lordship, may I be permitted to mention, your lordship, it's an execution application, your lordship. Today is the third occasion I'm mentioning, your lordship.
Maybe you can mention 10 more times. What is it that you want?
Lordship directed the matter to be mentioned after 3 weeks, your lordship. So for inclusion, your lordship, there was directions for the matter to appear on 24th of July, 2023 upon notice to be served upon the other side. I've already served.
What
your
is the stage of the EC?
Lordship, the award, lordship, the decree, I'm for the decree holder, your
What is
lordship.
the stage of the EC? Has it been taken up for hearing or not?
No, lordship,
Then
only.
say that. It's the
lordship.
first time.
First time, lordship.
Yes, কবে আসে এগুলো? শুক্রবার? Yes, 6th October, notice to the other side.
Grateful to you, lordship.
Yes. Sorry?
I am appearing for the other side. Mr.
So one of you mentioned, make up your
My lord,
minds and mention, please. Don't waste the court's time.
I
Yes.
appear for the
Microphone, please.
I appear for the award holder, my lord. I'm mentioning an execution application from 2021. There's no stay of the award. Lord, in the past, your lordship.
You're the award holder.
I'm the award holder, my lord. In the past, my lord, your lordship has.
I can't hear you. Microphone, please.
No,
Yes.
In this matter, my lord, your lordship has perhaps appeared for one of the parties in the arbitration at some point of time. So your lordship.
It's running in the list.
No, my lord. So I'm just, your lordship has released the connected section 34 application in the past, my lord. So I was just saying that the execution application maybe.
Yes, to be mentioned tomorrow.
May I have your lordship's leave to mention?
There are two execution.
Yes, Mr. Sancheti, microphone, please. Yes.
My lord, there are two execution application, one filed by my learned friend and one filed by me on behalf of the.
Yes, to be mentioned both matters tomorrow.
Yes, may I have your lordship's leave to mention? I am appearing, your lordship, for the award holder. There is an execution application. Now, your lordship, this particular matter was supposed to be listed 2 weeks after the summer vacation, but it has never been listed. We have mentioned twice. The urgency right now, your lordship, is the award debtor is being creating a third-party interest in his properties. And if the matter is not listed, your lordship, we won't be able to enjoy the
So
fruits of
third
the
party
award.
interest is part of the petition as filed? Or are you saying this on subsequent knowledge?
No, your lordship, it's a subsequent knowledge because we have
Not,
included the
not before
property.
the second week of October? Yes, second week of October.
Grateful,
13th.
your lordship.
May I have
Yes.
your lord's kind leave to mention upon notice, it's an execution petition, my lord. It was taken up by your lordship, but my lord, there was a section 34 which was filed by the other side. My lord, section 34 is now disposed of by an order of 21st March 2023. But I'm only praying if the matter may be listed, the execution petition. But
Yes, 13th, notice to the other side.
I'm very deeply.
You have to wait second time. Any other person? first time. Yes.
My lord, may I have lordship's kind leave to mention a matter? This is my section 11 application, my lord. On the last November, my lord, 18th November 2022, this matter last appeared, my lord, where there was a direction on the respondents to file the affidavit in opposition. After that, this was not listed, my lord, and they did not file.
When was it last taken up on?
18th November 2022.
Very well. You mentioned in the second week of October.
My lord, if I may have my lord's leave to mention an admiralty suit, my lord. A vessel was arrested, my lord, and subsequently there was a direction for the sale of the vessel, my lord.
When?
My lord,
Sale of the vessel, I'm appearing for the plaintiff, my lord. The vessel was arrested on my instance. The vessel was arrested on 29th of September 2022, my lord.
Yes.
Thereafter, my lord, on the 15th of June 2023, my lord, receivers were appointed for sale of the vessel.
My lord, I am the receiver who has been appointed, my lord.
Yes. Wait, Bhattacharya, you cannot barge in. Please wait. Yes.
Well, the issue right now which is cropped up is, my lord, in the order, my lord, of sale, my lord, the EMD has to be deposited by the prospective buyers, my lord. Now the order is silent on where the EMD needs to be deposited.
Order
That is
passed
the
by this court.
Order passed by Justice Kapoor. As that point, Justice Kapoor had the determination.
So why did you not mention before Justice Kapoor and say that this order needs to be added to or whatever?
My lord, did not happen at that point of time. Lordship has determination now, my lord.
Maybe
We are seeking
my
clarification.
determination is only for the last, at least in these matters, only for the last 3 weeks. Why do, and the order is dated when?
Well, the order is dated 15th June 2023. The suit is of 2022, my lord. And the lordship has determination.
No, you're not getting my question. Yes. What do you have to say?
my lord, I was praying, my lord, if my lord would kindly consider keeping it as to be mentioned, my lord, for the order to be modified to the effect that the registrar original.
When did you file the application modification?
The application has not been filed.
File it, then we shall see. Yes. Yes.
Section 215.
I can't understand what you're saying.
Hello. There's a content application.
Original side?
No.
You don't know that original side mentioning is going on? Yes, any other original side?
By your order dated 4th September 2023, your lordship appointed one arbiter, namely Chameli Shengupto. It's not traceable, lordship. We have tried to find so many times, we have taken the help of court officer also.
Okay. Yes, to be mentioned tomorrow.
My lord, may I permit to mention this matter, my lord? This section 11 application, the pleading has been completed since 2022-24 June. But after that, the matter is not included.
Very well. It will appear after the puja holidays. Yes.
May I have you kind leave to mention 2 matters? Lordship, similar matters. It's an execution case. Lordship, we are on behalf of the judgment debtor. The matter has not been taken up once even, and the judgment debtor is suffering due to the pendency of the matter, Lordship.
When was the matter last taken up?
In the last week of June, when the judgment debtor
Don't
filed-
even know. Yes, you come back after the puja holidays. Yes, original side mentioning. Yes.
May I have your lordship's leave to mention one section 34 application, my lord, filed by the award debtors, my lord. I appear for the award holder.
Naturally, award debtor will file a 34. Award holder can't file.
But
Yes.
I appear for the award holder, my lord. This award is of July 2018, my lord. And my lord, there is a delay of more than 2 years, my lord.
Yes, come back after the puja holidays. Yes, appellate side.
Appellate side mentioning. I think my lord's kindly to mention a matter, contempt matter, my lord. My lord, my lord.
Don't know the date. Yes, yes.
It is also content matter.
I will start imposing costs on counsel who come and mention in a way without even knowing any facts. I will start doing that from next week. Yes, or maybe from this
Order
week.
was passed by
I can't understand what you're
lordship
saying.
was passed. Your lordship passed an order in the year 2022, 21, 22. That was
Make up your mind, 21 or 2022. Come back on the next day.
21.
Come back on the next day. Yes.
2020.
No, come back on Thursday.
May be
Yes.
permitted to mention, my lord, and contempt application for inclusion in the list. Order was passed by your lordship on 17th of April 2023.
Yes, contempt of Friday. 29th.
May I permit to mention, my lord, for contempt, my lord, order dated on 22nd of my lord, February 2023, my lord. The lordship was directed the block development officer to decide the issue. Nothing was to do.
29th.
My lord, may be permitted to mention, my lord, contempt application, my lord, where the order was passed on 11th May 2023, my lord, directing the Union of India to, my lord, release pension payments, my lord, of my father, my lord, which were pending, my lord. My lord, we've exchanged, my lord, correspondence, my lord, yet no payment has come forward, my lord.
Yes, 29th. Call on the list, please. Call on the list.
Commercial division matter.
Item number 1, Bridge and Roof Co.
My lord, this is a, my lord, disposed of application, your lord. My lord, by 15th of June, your
Wait, wait,
lordship
wait.
has
Yes, keep.
disposed it. Oh.
Yes, just to put on record that the bank has sent the draft of the bank guarantee.
My lord.
Yes, just to put that on record.
Very well.
Yes, this matter has been listed at the instance of the court. Stop. The report of the registrar original side dated 8th September 2023 records that the office, that the registrar's office, capital O, has received a letter from the SBI forwarding the original draft dated 8th September 2023 amounting to rupees 46,38,292 issued by SBI for invocation of the bank guarantee. Stop. The original bank guarantee is with the department. The report also records that the original bank guarantee is with the department. Stop. Next. The order which is relevant to the report is of 30th August 2023 on an application by the award holder for withdrawing the amount mentioned above. Stop. The application was allowed by extending the time to the award holder to file the bank guarantee within 10 days from the date of the order. And the applicant was allowed to withdraw the said sum from the register original side. Stop. Have you done that or not?
Yes, ma'am, within
Yes.
time.
Sorry?
Within time, we have deposited.
Yes. Next, the parties are represented today, and learned counsel appearing for the applicant / award holder submits that the award holder has already withdrawn the money,
No, my lord, I have not withdrawn. I have deposited the bank guarantee, original
that the
bank.
award holder has deposited the bank guarantee within time as directed by the court. Stop. Next, department look. Very well. The concerned person from the department is present in court and informs the court that the award holder will be at liberty, will be in a position to withdraw the money by 22nd September 2023. Next, since the application was disposed of by the order dated 30th August 2023, nothing further remains in the matter.
My lord, item number 21 is a connected application to this matter, but the application has become infructuous. we have taken out an application to substitute the bank guarantee by way of demand draft, but the application has become infructuous.
Item 21 of
Item
today's
20
list.
Of today's list, 21.
You are appearing for who?
I am appearing for the award data, madam. That's our application.
And 21 is for what?
For substituting the bank guarantee by way of an demand draft. But it has already been invoked. And
Very well. You're the advocate on record.
Yes, madam.
The advocate on record next. The advocate on record of the award debtor submits that GA4 of 2023 in AP 831 of 2019, which is appearing as item 21 in today's list, has become infructuous. Stop. The GA4 of 2023 is accordingly dismissed as having become infructuous. Next.
Item number 2, Mrs. Palmek.
My lords, item number 2 and 3, AP 444 and 449, my lords. It has been listed today, my lords, for filing the written note on submissions. My lords, we are ready with our written note, my lords.
Yes. This is the first time you're filing. I thought I've seen, already seen the written notes. I hope I'm not confusing it with some other matter.
My lords, we are filing it for the first time. My lords, along with the written note, we are also filing a case compilation, my lord.
Don't be surprised if I pass judgment on this matter with some other cause title.
For my lord's convenience, we have also prepared a case compilation. My lord, if you can hand up the case compilation also.
Yes, this is that incorporation argument, 7.5.
And my lord, the Stamp Act argument where the applicability of section 4 has been contended by the respondent, my lord.
Yes. This compilation is by you?
Yes.
By the petitioner?
My lord.
We had handed out the copies of the judgment.
Mr. Das, microphone please.
But we had handed out the copies of the judgments relied upon by us. If your
Yes,
lordship desires
but
it.
did you cite at the time of making submissions?
My lord, it's
Then
all.
why have you filed a compilation again? Because all the copies are marked and they have my notes.
Very well, my lord, then that can be ignored, my lord. My lord, there is one small prayer, my lord, I need.
Yes.
My lords, 449, 444 and 449. My lords.
Yes.
My lords have been taking up this matters together, my lords, because the disputes.
No, 440 is what?
444 and
Yes.
449.
444 is what?
My lord, both are section 11 petitions.
Both are
my lord.
11, yes.
Because my lords, the parties and the.
No, you have filed both.
I filed both.
Yes.
So, and it has been taken up together since the inception, my lord, because my lord, the point of law, the contracts, the parties, everything is same. So, my lord, my only humble submission is, my lords, I'm not even remotely praying that a common arbitrator be appointed. There will be 2 arbitration proceedings, I understand that. But if my lord is with me in this matter, my lord, then my lords, the same arbitrator can be appointed for both the matters, my lord.
So then why are you saying that that you're not remotely praying that a common arbitrator be appointed?
Because, my lord, I am praying for, my lords, let me clarify. I have not been able to put it properly, my lord. My lord, I'm saying a common arbitrator be appointed, but that does not mean that there will be one arbitration proceeding. There are 2 section 11.
So you want one arbitration, one arbitrator for 2?
One arbitrator for 2. My
Why?
lord, I'm praying.
Why?
My lord,
Because I will be passing one judgment, that's all.
We're grateful, ma'am.
Yes, yes.
Great.
One judgment.
One.
Yes, Mr. Das, what do you have to say?
My lord, on this point.
Both are section 11s.
Both are section
And the
11.
point was one, the Stamp Act, the other was incorporation.
My lord.
Yes, but in both. Now, my lord, so far as consolidation of these 2 arbitrations is concerned, both are at very different stages. Because in the first matter,
Both are at different stages.
Very
means
different.
Arbitration has not commenced.
Yes, my lord. In
They
the
have-
first case, my lord, I'll just explain.
I can't hear you.
There was an unilateral appointment.
Yes.
And the arbitration had commenced before the previous sole
No,
arbitrator.
no, but section 11 is for appointment of arbitrator.
Yes, my lord, but after a section 14, there was a
Yes.
section 14
Yes.
and that arbitration because of unilateral appointment was declared to be, my lord, ineligible.
Yes.
So, my lord, in the first matter, pleadings have been completed, arguments have been completed. It was only pending for award. So it's at a very different stage. And this 449, my lord, is a fresh section 21 notice for certain other disputes which have cropped up after this. So, my lord, if they are consolidated into one, it will lead to inconvenience. My lord, of course, my lord, so far as
So
whether it will be
449 arbitration has not started.
not started. It's a fresh section 11. But my lord, 444 is a section 11 after a section 14. My lord, appointment of the arbitrator is completely your lordship's prerogative. So we are not making any prayers that it should be a common arbitrator or separate. Our only prayer is no
yes.
consolidation.
Ms. Dalmia, where have you stated this in your note that there are two that one is fresh and the other one has already started?
My lords will just kindly take page 1, my lord.
Page 1?
My lord.
Yes.
My lords, under the heading AP 444,
yes,
I have indicated that this section 11 is filed after section 14.
So in 444, the arbitrator has already been terminated.
Yes, ma'am.
His mandate has been terminated.
Mandate has been terminated. And my lord, under the heading 449, I have mentioned that the cause of action or the disputes in relation to 449 has subsequently arisen.
Very well. Learned counsel appearing for the petitioner. Action করে দাও না 444 449 লিস্টে কি অ্যাকশন আসছে হ্যাঁ হ্যাঁ ট্যাগ করুন learned counsel appearing for the petitioner who has filed the two applications under section 11 of the act for appointment of arbitrators comma submits that one arbitrator may be appointed but in two different arbitration proceedings. Stop. Next, learned counsel appearing for the respondents in these matters submits that consolidation of arbitrations may lead to confusion since 449 since AP 449 is an application for fresh appointment, whereas AP 44444 is an application for appointment after termination of after the termination of mandate of the erstwhile arbitrator. Stop. Next, council have handed up their respective notes. Stop. List this matter on September 2023. Grateful.
I don't know for Mrs. Street Engineering. Madam, this is my application for appointment of arbitrator. This is my application for appointment of arbitrator under section 11 of the Arbitration and Conciliation Act. On the earlier occasion, Lordship has directed exchange of affidavits, madam. But the affidavit in reply has been affirmed and dispatched from Bangalore, madam. It has not yet reached my solicitors.
You're in Bangalore?
Yes, madam. Madam, kindly keeps it day after tomorrow if it so commences to Lordship.
Yes, learned counsel appearing for the petitioner prays for time on the ground that the affidavit in reply is yet to be affirmed. Stop. List this matter on 25th September 2023.
Item number 5, Mrs. South India.
Petitioner advocate Mr.
I can't understand.
Petitioner advocate Mr. Rudra Prasad Motilal has not come to court due to his high viral fever, my lord. That's why, my lord, I am praying not this week. my lord.
It's a section 11 application. I'm really not opposing this because I also have my counterclaims. So.
Very well, you're the advocate on record.
No, my lord, he is on.
Yes, adjournment is paid for on behalf of counsel appearing for the petitioner. Stop. List this matter on 25th September 2023.
Only one indulgence, my lord. I know your lordship would really admonish me, but in item 45, I have some difficulty today. My lord, could somebody would be there. My lord, may I come back tomorrow? My lord?
Mr. Gupta, what is this? You're mentioning a matter.
Yes,
Please
my lord.
don't do these things. Call on the next matter, please.
6, Mrs. Ponchudeep Construction.
This is my application under section 11, my lord. Lordship, in this matter, the seat was in Delhi.
Microphone, please.
The seat was in
Where
Delhi.
is your, this is 11. Where is your other side?
Lordship, we have been served. They have been
When?
served for the not.
So first show that before making your arguments. When were they served?
The affidavit of service is there. But affidavit of service to them.
Yes, where is the affidavit of service?
Lordship, the affidavit of service has been filed. I am carrying a copy of the affidavit of service.
এখানে নেই, দেখো কোথায় আছে। Where is the postal tract report? Doesn't have it. The affidavit of service is not complete. Stop, list this
That report
matter.
is At
Yeah.
page 5, my lord. Lordship, it is received on 23rd August 2023 at 12:55.
How do you, where do you see that?
Lordship, it's page 5, it's a DHL E-dot report. Lordship, right, it's a way bill. Date of delivery is 23rd August 2023, time of delivery 12:55. The gentleman who's received it is called Rahim.
Very well. It's 23rd August. You have to come back once again and communicate this order on them. They're based in Gurugram.
Yes, my lord.
Yes, the affidavit and report, the affidavit of service contains a report from the courier from the courier service company showing that the respondent received service on 23rd August 2023. Which appears to be yes, Kerala, 23rd August 2023, stop. Next, since the respondent is based in Gurugram, Haryana, list this matter when?
Whenever it's convenient to your lordship.
Any day to speak. You have to communicate this order on them.
Lordship will kindly give us 2 days' time.
Yes, list this matter on 21st September 2023 as prayed for. Stop. The petitioner shall communicate. The petitioner's advocate on record shall communicate this order on the respondent.
Lordship, a direction was given for filing a supplementary affidavit because an application under section 11 has also been filed in New Delhi. We have disclosed it by way of a supplementary affidavit.
Yes, the supplementary affidavit is taken on record. Next.
Item number 7, Rahul Enterprises.
By section 11.
Just 1 minute, please. Yes.
This is my section 11 application.
Yes. 11.
Yes.
You're for the
I'm for one of the.
microphone, please.
Well, I am for one of the respondent, my lord. Before my learned friend.
One of the
starts-
respondents.
Well, yes, yes, my lord. This National Jute Manufacturing Company, my lord. My lord, I feel-
Microphone, please. I can't hear you.
well, I'll be just praying for my lord, 2 days time. Well, I have not received the copy yet. My lord, the copy has been served to the authority, my lord, but I have not received it, my lord.
When did you serve it?
On 6th of September,
6th September,
affidavit of services.
18th. Yes, make your arguments, please.
The arbitration clause is contained in
If
a
you have an
clause
extra copy, give it to Mr. Chattopadhyay, please.
of the petition, my lord. I don't have a copy.
Very well. Then you strain your neck and see what's there in the application. Yes.
I know the arbitration clause is contained in a job works contract entered into between the petitioner and the respondent, my lord. The
Job works contract.
Yes, my lord, of 27th October 2014. That is at page 13. And the arbitration clause is clause 12 at page 27. The respondent.
1 minute.
Yes. The agreement was between the respondent and the petitioner for the petitioner to run the factory of the respondent. The respondent is a jute products manufacturer. So the petitioner was appointed for running the factory of the respondent at Bihar. And the responsibility of the petitioner was to manufacture jute B-twill bags of a specified quality.
What? Manufacture?
B-twill bags.
Yes.
If I may show my lord, page 14. Whereas the company is engaged in manufacturing of jute products and operates its 3 units located in the states of West Bengal and Bihar. B, in terms of the
Company is who? You.
the respondent
Yes.
is engaged in manufacturing of jute products and operates its 3 units located in the states of West Bengal and Bihar. In terms of the revival scheme sanctioned by the Board for Industrial and Financial Reconstruction, the company is required to achieve certain estimated production capacity to make its net worth positive. C, the company has invited bids from experienced and registered contractors by floating a tender on 17 September 2014 to achieve specified guaranteed production of jute bags of 665 grams, sacking B-twill in its RBHM mill in Katihar, Bihar.
So you're the contractor?
Yes, my lord.
Yes.
So I was appointed as the contractor. I was supposed to manufacture. There was a minimum production requirement by the petitioner.
So what is it? Unpaid bills?
Unpaid bills, my lord. The raw materials were to be supplied by the respondent, jute, power, and fuel. Our claim is that the jute that was supplied was of low quality, due to which we could not meet the minimum production requirement. On the basis of that, my lord, we had suspended work in the factory, and thereafter they have terminated the agreement.
When?
The termination was on 16th January 2016. That is at page 35.
Yes. And after that, what steps did you take?
Thereafter, my lord, we had submitted the invoices to them of about 9.91 crores. They have paid certain amounts, and still 5.47 crore is due. We had filed a petition under Section 9 in the National Company Law Tribunal, my lord, but that was dismissed due to default, my lord. It was filed in 2019, and thereafter, due to COVID, we could not pursue it. So it was dismissed for default. No steps were taken. It was not admitted. Thereafter, my lord, we have sat with them. They have made some payments in 2023, May, June. We have annexed the bank statements, my lord, at pages 38, 41, and 40.
So payments made before and after. You said
Before
some
and
payment.
after. Yes.
Some
yes.
payment made before the
Section 9.
NCLT proceedings.
Yes.
And you said 5.47 due. So 5.47, that number changes or that number
Because
remains?
with interest, it remains more or less the same, my lord.
Yes.
And they have made these payments. We have annexed the bank statement, my lord, at pages 38, 41, and 43. These payments are reflected. And thereafter, my lord, we have written to them on 10th of June, 2023, asking them to appoint an arbitrator. However, they did not reply.
That's your Section 21.
No, that was not our Section 21. Our Section 21 is of 5th August, 2023. That is at page 47.
No, Miss Bormon Roy, please. 10 June 2023 is at which page?
Is at page 45.
And that is what then?
We were asking them to commence arbitration, but in terms of the clause 12 of in terms of the arbitration agreement, we were supposed to appoint arbitrator. So we issued a formal Section 21 arbitration invocation notice on 5th of August, 2023, which is at page 47. We have appointed our arbitrator.
Very well. And what did they do?
They have replied to us. They have raised a counterclaim saying that the amounts that they have paid in May, June 2023 is in excess of what they were supposed to pay.
And how much have they paid? 9.91 crores.
No, my lord, they have only paid about 51 lakhs. So
No, you said 9.91 crores was the initial due
was
and
the
some.
initial amount. Thereafter, they paid some amounts. And thereafter, 5.47 was due after payment of the.
So after payment of 51 lakhs.
Yes, now 51 lakhs has been, no, 51 lakhs has been paid after 5.47 crores.
No, 5.47 crores you said is the due, is the outstanding due.
Yes, I apologize, my lord, because with interest, it is more or less 5.47 crores.
So how much have they paid in total?
They have paid 51 lakhs.
In total, 51 lakhs.
And they are saying that is in excess of what they are supposed to pay.
And have they disputed the arbitration clause?
No, my lord can take a look at the reply, my lord, that is at page 52 of the application.
And what do you say about the interregnum, the time in between?
My lord, initially we were trying to reconcile and kind of settle the matter between ourselves and hopefully not file proceedings. And thereafter we are saying that the breaking point would be their failure to pay our dues after the sittings and meetings that took place between the petitioner and the respondent. And hence they have paid only 51 lakhs, around 5 crores, little less than 5 crores still remain due and payable from them. Hence the breaking point is the failure on their part to pay the entire amount that is due, that is claimed by us. Hence, limitation would not apply. And they have also not taken the point of limitation in the
No,
reply.
maybe, but the
Yes.
court will have to
Yes.
see that point. And you have considered the T and AG of Justice Pardiwala.
Yes.
And how do you deal with that judgment? Sitting with the CGI, how do you deal with that judgment?
I was relying on, I don't have the judgment, my lord, Geo Miller, which says that the.
No,
period-
Geo Miller talks of breaking point.
Yes, my lord.
Geo Miller talks of breaking point, but Geo Miller has been considered in
Yes,
T and
in
AG, that
defense,
one,
yes,
Justice Pardiwala's judgment. So how do you take advantage of, forget about Geo Miller, how do you take advantage or how do you distinguish T and AG, that one?
By saying that, my lord, the initial period between the termination was in 2016 and the demand notice for section 9 was in 2019. So those 3 periods, those 3 years, my lord, they had made some payments. So, and we were sitting with them trying to reconcile the disputes. Hence, probably that period can be excluded for the purpose of computing limitation, my lord. And thereafter, they have made payments in 2023 and the limitation period, which will be excluded due to COVID, my lord, after 2019 till 2020.
So after 28th February 2022.
Yes, my lord. And
So then you're saved by that.
Yes, my lord. And thereafter, my lord, they have made payments.
So where is your first demand?
First demand is, which we have relied here on in this application, is 10th June 2023. But prior to that, my lord, we had sat with them. In fact, they issued a reply. We issued a reply to that. And now they have also again issued a reply where they're saying that there were meetings between the petitioner and the respondent in April 2023 for the purpose of clearance of dues. And they are saying that this amount is not payable by them to us. So they've raised certain counterclaims also, as they had raised in the reply, my lord. So this is the situation, my lord. They have not disputed the arbitration clause and disputes do exist between the petitioner and the respondent.
Yes, Mr. Chatterjee, tomorrow.
Give me kicks it on Wednesday, my lord.
Absolutely not. Tomorrow. You received the petition on, I have the date. You get ready and come back tomorrow. Why will you say Wednesday? You should have been ready today. Yes. No. Tomorrow. Section 11 can't be kept pending. Learned counsel appearing for the petitioner has made her preliminary submissions. Stop. Learned counsel appearing for the respondent seeks time. Stop. Next list is matter tomorrow. Next. As paid for. Next.
Item number 8, Say Equipment Finance. In this matter, I'm led by Mr. Shatarup Banerjee.
And 1 minute, Miss Bormon Roy, get the judgments tomorrow and be ready to distinguish them, please. Yes.
My lord, I am led by Mr. Shatarup Banerjee. He is engaged in other code. I am led by Mr. Shatarup Banerjee. He is engaged in other code. I also find, my lord, from the
postal report, my lord, the service is not complete. It's showing item received, but not showing.
Show me,
item
show me the affidavit service, please.
It's not showing item delivered.
No, it's showing item received.
Item received. It's showing item received. Only 1 day time, if you watch. Section 11.
Yes, the advocate on record, the petitioner seeks an adjournment on the ground that the affidavit of service does not show delivery of the document. Stop. Next, list this matter on 21st September 2023.
Item number 9, Dilip Kumar Chatterjee.
I oppose to the
This is
statement.
my
I'd like to use an
application,
affidavit
Lordship.
in this matter.
Lordship, this is my application, Lordship. Application for withdrawal of the amount deposited under 36(2), Lordship. Lordship, I'll show the orders. Initially, there was an application. Lordship, page 12 is the order. Page 12 is the order by which the direction was made upon the award debtor to deposit 6.8 crores.
Page 12.
Page 12, order dated 25th March 2022. Here, Lordship, they are directed to deposit 6.8 crores.
For in Mr. Sinha's application for stay.
Yes, ma'am. Now, Lordship.
1 minute, where is that 6 point?
Yes, 3.4 crores, Lordship will see the page 13.
Yes.
3.4 crores by cash and 3.4 crores by bank guarantee.
Yes.
This was later on modified to be entirely cash, but that is not the dispute here, Lordship.
6.8.
6.8 crores.
Yes.
Now, I make an application for withdrawal of this amount
Yes.
on furnishing bank guarantee. A judgment is passed at page 17, Lordship. At page 17, the operative portion, Lordship, will kindly come at page 25. Page 25, first paragraph, the operative portion. I was allowed to withdraw only 50%, that is 3.4 crores.
Where is the reason for that?
And there is no reason for not rejecting the remaining part, but this is the only operative part with regard to allowing 3.4 crores. There is no discussion and no rejection with regard to the remaining 4.3. Now I went up in appeal before the Honorable Supreme Court. There is no, the Honorable Supreme Court refused to interfere with the order. Page 26.
You went up in appeal because you wanted the other, the remaining 50%.
Yes. Page 26, the Honorable Supreme Court refused to with
No, the reason is at page paragraph 15. 14 and 15.
14 is my surfacey notices that I have received, and 15 is their strong arguable grounds.
No, who is 75 years old? Not Mrs. Sinha.
No,
Yes.
my client is 75 years old.
Yes.
Now, after this Supreme Court's order of not interfering, Lordship, the
Well, strong arguable grounds.
yes. Now, I received a notice from my banker at page 27. Lordship, this is the change circumstances by which I have come up again.
27.
27, Lordship. Letter dated 11th August 2023.
Yes.
Lordship will kindly have a look. I'll just read few paragraphs of that letter, Lordship. Pursuant to our letter dated, I'm sorry.
Yes, yes, yes.
Pursuant to our letter dated 14th July 2022.
What is the date of this letter?
Lordship, at the top, 11th August 2022.
Yes. Yes.
Pursuant to our letter dated 14th July 2022, you were directed to pay the entire dues of 38 crores odd, which were sanctioned against cash credit loan overdraft.
No, what is this for? This 38 crores?
This was on with regard to cash credit loan overdraft I had taken. This was the, they had issued a letter on 14th of July directing me to pay back. Whenever you are asked for.
No, but is this related to the dispute or something else?
Related to, I have been, my banker is issuing notices to me directing me to pay back the dues. And whatever I could say to them is there are several awards pending on which I have not been able to get the amount. This work, Lordship,
No, this banker's letter is for which dues? That's what I'm asking you.
includes this dues. Lordship will kindly have a look. That is why I was reading, Lordship. Second paragraph. Whenever you were asked to repayment, you were showing excuses that soon after obtaining awarded amount from Honorable High Court, all dues will be paid without delay. But till date, you have only paid 3 crores 40 lakhs. This is that 3 crore 40 lakhs which I've got. The financial assistance were taken by you as indicated various point of time for different government construction works under the state of West Bengal. But you also created mortgage of creating security in favor of the bank. As the operation and conduct of the overdraft has become tremendously irregular and the debt in the near future after due notice to you in accordance with the procedure under Surface Act may be classified as NPA. If you fail to pay till 30th September, the bank will not exercise rights under the preventive laws. Now, what I was saying, Lordship,
Why have you made this National Highway party?
National Highway.
National Highway Circle 2 and 3. Parties 2 and 3.
No, they're not national highways, sir. They are part of the West Bengal PWD, Lordship. The superintendent engineer. They are part of this contract.
Yes.
Now, this work, I have the award with me, Lordship. This award is of the year 2012. Work was completed in 2001. I am 75 years old. I need to pay off what I was seeking today is.
Award is of 2012.
2012. I was seeking to.
And what is the status of the 34?
Nothing. It's
What do you mean nothing?
It's pending. It's pending.
What is the name of the arbitrator?
Justice BHATTACHARYA.
Yes.
Now, work completed in 2001. In 2023, I'm 75 years old, I'm running for the money, I'm receiving bank's notices. All that I'm seeking without prejudice to the award debtor that I will be securing the amount by way of a bank guarantee. I want to get this money released and pay off to the bank. That's all that is going to happen, nothing more than that. And I'll be furnishing the bank guarantee and the state will not be prejudiced at all.
What is the status of 34? I'm asking you.
The affidavits are complete. That is the
Last taken on?
Last taken when the order was passed in this 20 before not in this year, Lordship.
No.
Not in this year.
No, like it has 23 February.
February.
Yes, Mr. Sinha, what do you have to say?
Lord, there are a lot of facts. I like to not use an affidavit in this matter. Lord, just not to briefly indicate. Lord, they had made an application. Lord, we had filed an application to section 34. So thereafter, that was in 2012, and thereafter, we had filed once the law changed. We applied for stay.
34 is of 2012.
2012.
Yes.
Yes, that's also some relevance, Lord, because what submissions I'll be making. Lord,
what is the date of the award?
Lord, it's 25th April 2012.
Yes.
Lord, section 30. Lord, after Lord, we had filed section 7, but it was hearing was concluded by the state, not by Justice Arindam Sinha. No, thereafter, not on a couple of occasions, they did not appear.
The award was stayed.
No, ma'am. Section 34 was heard by Justice Sinha, my lord, and our part of the hearing was concluded. But they were not there on the next day, so hearing could not be concluded. In the meantime, the law changed, but we were required to not put in the security. Lord, after that, the application came up before Justice Kapoor. Lord, that order is at page 12. Lord, we were asked to not secure the entire amount with interest. Lord,
yes.
Lord, what is important thereafter, they made an application for getting this entire amount of 6.8 crores. And Lord, interestingly, Lord, that application was taken up, and we had filed an affidavit to oppose that application. And Lord, after considering, Lord, this honorable court, Lord, was pleased to find that there was arguable grounds made out, and therefore, Lord, to balance the convenience. Therefore, to balance the convenience between the parties, the court allows withdrawal of only 50%. Now, that rejection of 50% was challenged before the Honorable Supreme Court. And the Supreme Court refused to interfere with that. So, my first point is it's barred by res judicata. Because they had asked for this entire amount, which was refused. That refusal was challenged with the Honorable Supreme Court, and Supreme Court has refused to interfere. And now this, the new grounds, which he says that subsequent facts, that merely reiterates a letter given in July 2022 prior to this order. So it's not a new fact. That letter refers to, if your lordship sees, that letter refers to and their letter
July
of
2022.
14 July, which is prior to prior to this order. This order, my lord, is of 30th January two thousand
Maybe,
twenty-three.
but 11th August 2023 letter, that says NPA and all that. Did the 11th,
Yes, my lord,
did the,
my lord, it's reiteration of the letter of 14 July.
no, but did 14 July say the same thing? Where is the letter
No,
of
that's
14
not
July?
an explanation. That's what I wanted to use an affidavit note to this application to bring on records all the orders. No, that's one.
You can bring an affidavit, but by Wednesday. You can, if you want, by Wednesday, affidavit. Yes, anything else, Mr. Secretary?
Another point, my lord, section 34, my lord, was last note I find was heard on, my lord, this, my lord, appears, my lord, to be an attempt, my lord, to set up, my lord, one court against the other. My lord, why I'm saying this, my lord, kindly, my lord.
No, last heard on when?
My lord, it was heard, my lord, sometimes in February, my lord, but section 34, my lord, is to be heard by Justice Kapoor.
Yes.
My lord, why I'm saying this, my lord, kindly, my lord, take the cost title of the previous application. No, there has to be some reason why there's a departure from the previous practice. Lordship takes the cost title of the previous application. My lord, that is filed, my lord, in AP. My lord, it has to be filed.
Which
My lord,
page?
page 17, page 17. Annexure C. My lord, this application is required to be filed in my section 36. And that was done by them in the previous occasion. My lord, AP 557 of 2012, my lord, GA 3 of 2022.
Yes.
And my lord, this time, my lord, it's an independent application. Now, my lord, section 34, my lord, will be heard by another court, and not 36, my lord, will have to be heard by another court. My lord, by this change, my lord, of this mechanism.
No, what happened on 27th February 2023, Mr.
Section 34 was heard by Justice Kapoor once.
And then after that, what happened?
But after that, no, it has not appeared in the list yet.
And Mr. Shaha, what have you done after 27th February 2023, when the 34 was not taken up by Justice Kapoor?
Lordship, we had mentioned the matter. It was mentioned at least, I have the mentioning notice, it was mentioned at least twice, the matter was not taken up. All that I want, Lordship, I could not understand what is my learned friend saying. I'm not saying, it's not setting up I cannot make an application in the disposed of application. His application is already disposed of. How can a miscellaneous application come up in a disposed of application?
That's what he did
All
last
the
time.
all the applications were disposed of, and that is why I made an application. I'm entitled to that in the law. I have to make a separate application under the changed circumstances. All that I'm saying is, I do not understand what my learned friend is seeking is to take the matter away from this court. I rest my case there. I do not.
I'm not saying that.
Yes.
All that I want is that Lordship had passed a judgment on this aspect of law. Lordship, the judgment dated 25th of July 2023.
On this aspect of the law means what?
Or
Which
withdrawal.
aspect?
Withdrawal of the amount. Lordship will kindly come paragraph 13 of that judgment.
Yes.
In the present case, the subsequent events pleaded in the application constituting a change in circumstances after the order of stay of the award are follows. Proceedings were initiated against the award holder under section 13(2) of SURFACE.
No, that's
These
all. Those are facts. then.
Yes. The Lordship's reasoning at paragraph 14 and 15, Lordship. The prayer for withdrawal of the amount deposit security is in constant objective of the act. Such an order will of course be refused if it rendered the award debtor without a remedy. This can only be where the award holder departs with the money without ensuring a security cover for the award debtor in case the later succeeds in having the award set aside. The object of the amendment in the act in granting stay of an award cannot be made the award holder to wait for an uncertain indefinite period of time to enjoy the fruits of the award. This is particularly so where the award holder proves his bona fides not only by bringing significant subsequent events to the court, but also undertakes to secure the award debtor in the event the award is set aside. In the present case, the award holder undertakes to replace the amount to be withdrawn by way of a bank guarantee of an equivalent amount. The award holder will hence be completely secured in the event it succeeds in the application for setting aside of the award. No inconceivable prejudice, whether immediate or in the future, will hence be caused to the award debtor if the award debtor succeeds in setting aside of the award. Paragraph 18, Lordship, thereafter. Paragraph 18, a prima facie finding. I'm sorry, Lordship.
Yes.
A prima facie finding by its very definition means a first blush look at the factual as context of the matter for consideration whether an award may be stayed under 36(2). The court simply looks at the bona fides of the award debtor in having a way to secure the award. Hence, the inexplicable conclusion is that the award holder is not required to make out a prima facie case for withdrawal of the security given by the award debtor. The sustainability of the award under the grounds provided under section 34 is to be
Very well.
thrashed out.
Don't read anymore.
I'm
I've
sorry.
read it also. And what about the res judicata angle,
Lordship,
Mr.
separate
Shah?
application. That is what I was reading. Next, after paragraph 18, can the award holder's application for withdrawal not be made by way of a separate application? The learned counsel appealing for the award argues that the award, paragraph 20.
Yes.
The argument is fallacious since the application for stay of the award is only filed for a limited purpose of the court to consider whether the award needs to be stayed pending hearing of the application for setting aside. The application is disposed of on a court coming to a decision as to whether the award is required to be stayed on the conditions to be imposed. The application for release of the secured amount is unconnected to a prayer for stay and is entirely different in cause and purpose. The award holder must show the intervention of even subsequent to the stay calls for decision as
Very
to
well.
whether-
Mr.
Now-
Shah, that is fine. I remember now. You please get that 16 July letter
Very good.
tomorrow. I'm keeping the matter tomorrow, 14 July letter
Lordship, not affidavit notified.
by Wednesday. Then I'm keeping the matter on Wednesday. Yes,
Then Lordship keeps the matter on Thursday, not Wednesday. I can use that.
very well. Yes, this is an application by the award holder in terms of arising out of an award dated 25th April 2012 for withdrawal of 50% of the security which was directed to be deposited by a coordinate bench on January 30th, 2023. Stop. Next, the Albuquerque record of the respondents seeks time to file an affidavit to bring on record subsequent facts. Stop. Next, although, comma, this court, although, comma, all the relevant facts have more or less been stated, more or less been brought to the notice of the court today, comma, the request is allowed. Stop. Affidavit in opposition. Next, affidavit in opposition by 20th September 2023. Stop. List this matter on 21st September 2023. Get the letter on the next.
Yes, miss. Grateful.
Thank you.
Item number 10, Calcutta Engineers.
My lord, this is my application under section 29A of the Arbitration and Conciliation Act. Lord, however, my lord, the service is yet to be complete, my lord. I was only praying, my lord, if your lord can kindly keep it any day after Thursday, my lord, so that. my lord.
Yes, learned counsel appearing for the petitioner seeks time on the ground that service is yet to be completed. Stop. List this matter on, they're in Salt Lake. Why do you need so much time?
My lord, it will be delivered by tomorrow, my lord. They might come back on Wednesday and say it is only
List this matter on 21st September 2023 as prayed for.
deeply oppressed, my lord.
Item number 11, National Plaster Products.
This application under 29A. We
Yes.
have filed it before expiry of the 1 year, 6 months.
Yes, Mr. Shah, are you opposing? Microphone, please.
I'm not opposed.
No. What is the stage of the arbitration?
The cross-examination of the second witness of the respondent is going on.
How many more witnesses?
No more witnesses.
I would-
No more witnesses. So it's a panel.
Yes, it's a panel. Kindly give us till we have prayed for 6 months. I was praying, it can be 31st of March. It's first extension.
6 months will take you to 31st of March.
No, 28th of February. I was praying, my lord, there are 1 month vacation, my lord, now, so I will be praying, my lord.
1 month vacation, everyone will work, including the
And the
court.
courts won't work, my lord.
I will be working throughout, so don't say all that.
Kindly consider that, my lord.
Yes, Mr. Shah.
I have no objection, my lord. Lordship will find, my lord, at page 208, the names of the tribunal as your lordship usually asks in these matters. And also, my lord, recording of extension of 6 months by consent.
And the 29A1, 3, all that is in order? When did the time expire under 1 and 3, Mr. Shen?
My lord, 1 year expired on 14th of February 2022.
Yes.
And then, my lord, further 6 months consent was given. Now, my lord, in view of the Supreme Court judgment that 1 year will commence from 1st of March 2022.
Yes.
2022, so that will one year expires on 28th February 2023 and 6 months thereafter on 31st of August. And I have filed the application on 25th of August.
Very good. Yes, this is an application for extension of the mandate of the Learned Arbitral Tribunal. Stop next. Learned Counsel appearing for the parties are ad idem on the mandate subsisting as on the date of filing of the application. Stop. The 12 months under section 29A within brackets 1 of the 1996 Act ended on 14th February 2022. Stop. The petitioner, however, took advantage of the Supreme Court orders passed in the suo motu writ petition in the wake of the pandemic and accordingly calculates the 1 year. You're calculating the remaining 6 months from 1st March 2023.
Yes.
And accordingly calculates the additional 6 months window under 29A within brackets 3 from 1st March 2023, from 1st March 2020. Mr. Sen, I don't understand. Please explain. You're calculating what from 1st March 2022? It should be 1st March 2022.
Commencement of 1 year period. Because when the Supreme Court order says.
When did the pleadings end?
The pleadings ended on 14th February 2022.
So you're calculating 29A1 12 months from 1st March 2022.
Yes.
And that is that will end on 1st March 2023.
28th February
2023. Very good. Yes. The petition and accordingly calculates the 12 months under 29A within brackets 1 from 1st March 2022. Stop. Hence, comma. Next paragraph. Hence, comma. The 12 months ends on ended on 28th February 2023. Stop. The parties consented to the additional 6 months under 29A3, which accordingly came to an end on 31st August 2023. Stop. Is that correct or not?
Yes.
Next, the court is informed that the second witness of the respondent is presently being cross-examined. Stop. Counsel appearing for the respondent submits that the respondent does not have any other witness. Stop. Next, considering the stage of the arbitration and the fact that the arbitration commenced on and from first date, reference.
Well, the first sitting is on 23rd January 2020.
And the fact that the arbitration commenced on and from 23rd January 2020, comma, AP number 615 of 2023 is accordingly allowed and disposed of by extending the mandate for a period of 6 months from today, 6 months from 31st August 2023.
If you could have the advantage of the, kindly give it 31st March, my lord.
Mr. Sen, no, 2020 it started, 3 years gone.
Wait,
Next.
only thing, well, 2020, we could not participate in that way because, well,
Mr. Sen, no, this is an unwritten rule which I have started. Absolutely not.
Your lordship will only consider, your lordship is.
Yes, don't plead, please call on the next matter.
But in appropriate matters, your lordship will consider, my lord, where the parties are consenting.
Mr. Sen, if you do it, I will say 4 months. Please don't do that.
I am
Call
not
on the
on-
next matter, please.
Not on that, my lord, we are
Yes.
trying to. present
Every matter
our
is
kind of
appropriate.
thinking.
Every matter is appropriate. Every matter, council will come and say voluminous papers, voluminous papers. It's absolute prerogative of the court. Call on the next matter, please.
But only
Call on the
for
next matter.
your lordship, the exercise of.
Very better 4 months for it out. 4 months. Call on the next matter. Call on the next matter.
12. Prejudice, my lord, kindly.
It's a pressure to the tribunal, not only on us, my lord, it's a pressure on the.
Mr. Sen, please don't say these things, all right? I work 24/7 to deliver my judgments. I didn't want to say these things in open court. Please don't say pressure on the tribunal. Don't say these things. Next, call on the next matter, please.
Item number 12, super.
My lord, this is my application under section 29A. My lord, this has become infructuous because the learned arbitrator's mandate expired on 9th of September. He had delivered the award on 7th of September.
What is this? I could not understand. What did
It's
you
an
say?
application under section 29A.
Yes.
My lord, the time was expiring on 9th of September. He has delivered the award the learned arbitrator has delivered the award on 7th of September. My lord, page 35 is the minutes of the arbitrator where from your lordship 34, it starts at page 35.
Very well. According to learned counsel opinion for the petitioner, the application for extension of the arbitrator's mandate has become infructuous since the award has already been delivered on when? 7th?
7th of September.
7th September 2023. Stop beyond time or?
Within time. 9th is mandate was expiring.
It's that the mandate of the learned arbitrator was till 9 September 2023. Stop. Next.
My lord will find it in his minutes of
AP 620/2023 is accordingly dismissed as withdrawn.
My lord, I have the minute by which one of the award was delivered, 7th of September. If your lordship so please, my lord.
Very well. Yes. Call on the next matter, please.
Great, my lord.
Item number 13, Tata Capital Financial Services.
My lord, I appear for the petitioner, my section 9 application. On last 2 occasions, I have prayed for time on the ground of settlement, my lord. The parties are settling this issue. However, the entire amount has not been paid.
This is
However,
what? This is a?
Section 9 application.
Section
My lord, I'll not trouble my lord. My lord may kindly allow me to withdraw this application. Whatever is due, parties will settle it.
Yes, learned counsel opinion for the petitioner seeks to withdraw the present application on the ground that parties are at an advanced stage of settlement. Stop. AP 255 of 2023 is accordingly dismissed as withdrawn.
No interim order was there.
Interim orders, if any, shall stand vacated. Next.
Item number 14, Ugru Capital.
Lord, I appear
Appearing for the petitioner.
Lord, I am
Mr.
appearing for
Ritovan
this.
Sarkar is appearing in this matter. He's down with high fever, so he's not able to come to court today.
Yes,
I'm
when do you
praying for
when do you want the court to keep the matter?
Lordship next week.
Yes, adjournment is paid for on behalf of counsel appearing for the petitioner. Stop. List this matter on 25th September 2023. Next.
Item number 15, Ugru Capital.
Lordship, in this matter also, Mr. Sarkar is appearing. I'm praying for
Same order.
notice.
Next.
My lord, I'm appealing for the respondent.
Sorry?
Number 1 and
Next.
Item number 16, Sunil Kumar Dubey.
Need a week's time to take further instructions in the matter, my lord.
Appearing for the first time.
No, my lord. Second time, the talks of settlement were going on. They have forwarded a copy, my lord. I have to take instructions further from my client, my lord.
Lordship, I'm also praying for not this week.
Yes, both parties pray for an adjournment. Stop. List this matter on 27 September 2023. Next.
Oblige, my lord.
17 say equipment.
And led by Mr. Shatrup Banerjee, my lord, he's on his legs before another court. Only praying for not today, my lord.
Adjournment is prayed for on behalf of on behalf of counsel appearing for the petitioner. Stop, list this matter tomorrow. Next.
Great.
Item number 18, Cholamandalam investment.
Milord, I would be seeking for an accommodation. Ms. Das, who assists Milord, the learned advocate on record, is severely unwell. And keeps this matter Milord next week.
This is what? 18
This
is
is a
what?
section 9 application. Milord. They were not represented on the last occasion. We have served them. Today they are appearing for the first time.
This is the second adjournment sought for on behalf of the petitioner. Stop. List this matter on 27th September 2023. Next.
Item 19, say equipment.
My lord, in this, this is a section 9 application. In this matter, I am led by Mr. Shatrup.
Microphone, please.
In this matter, I am led by Mr. Shatrup Banerjee, my lord. In this matter, on the previous occasion, my lord was instructed for the service to be completed. And I want to file the affidavit of service. And the service is already completed, my lord.
So then why are you seeking for an adjournment?
My lord, Mr. Shatrup Banerjee will argue on this matter. This is in section 9 application.
Yes, adjournment is paid for on behalf of counsel appearing for the petitioner. Stop, list this matter on 28th September 2023. Next.
Item number 20, welcome retail.
But I am opposing this application.
Petitioner lordship.
Microphone, please.
Lordship, this is my section 9 application. In regard to your lordship, there is a dispute. There is a dispute in regard to the encashment of the bank guarantee, which has been encashed by the airport authority. Your lordship, I kindly before.
Why are you saying there's a dispute? It's not a 11, it's a section 9.
Section 9. Yes.
So what is the case?
The case is that for running a retail shop at the airport, led by Mr. Mittal.
Continue, please.
Your lordship, this is a dispute.
Microphone.
Your lordship, to continue the retail business at the airport, Netaji Subhash Chandra Bose International Airport, the petitioner is required to submit a bank guarantee, the security deposit in form of bank guarantee and cash. Your lordship, the petitioner has deposited its bank guarantee and cash in the year 2016. Before there was some area due in respect of the rent, which was required to be deposited to the AI. The petitioner has failed to deposit at the rent. That's why the airport authority has encashed the bank guarantee and the cash component. In furtherance to that, the petitioner is required to further deposit.
What is the BNC? What is the notice you want state?
Your lordship, the notice is at page 402.
Yes, Mr. Mitra.
The notice is the notice of intent to terminate.
No, there's a that is prayer A. Prayer A is something about termination. What is prayer BNC?
Milord, prayer BNC, Milord. Yes, Milord, 4th September is the notice, Milord.
Yes.
Of intent to terminate. And prayer A, Milord, is the agreement which they are seeking to terminate. I'll just indicate, Milord, very briefly what happened.
No. What do you mean? There's a concession agreement which they have already terminated.
No. That's the agreement, Milord.
Yes.
Of 30th March 2017.
Mr. Mitro, I don't know the facts. I'm just looking at your prayer A.
Yes. 30th March 2017 is the concessional agreement.
Yes.
That is what, Milord, they are seeking to terminate by way of this notice of September 4, 2023.
Yes.
Hence, Milord, we are seeking, Milord, a stay, Milord, on this notice. And I'll tell you, Lordship, why, Milord, we are seeking the stay. Milord, this is a second round of litigation. In the first round, Milord, there's an award in my favor of about 6 crores and odd. They have secured the award. We went for execution. That, Milord, is a closed chapter. We preferred a section 9 when they wanted to, Milord, terminate way back, Milord, in April. We got an order. The order has been subsequently vacated on the ground, Milord, that
what order?
Milord, of stay.
Stay of?
notice to terminate.
So you got an order, but that was vacated.
Yes, on the ground that High Court has the jurisdiction in view of section 42. Because there was a earlier proceedings which was before the High
So
Court.
where did you apply for stay?
Before the Rajarhat commercial.
Say that, Mr.
I'm
Mitra.
sorry.
Don't make the court ask you these questions.
Sorry.
Otherwise, it's not making sense if you say 42. Yes.
So, on that ground, the Rajarhat Commercial Court, said that since I don't have jurisdiction, you apply. Thereafter, we had made an application before your lordship under section 11. Learned retired Judge was appointed as the arbitrator by your lordship. Unfortunately, because of his health, he refused to take the appointment, and we have taken steps to for further appointment or naming of the arbitrator. Now, in the concessionaire agreement, if I may just come back, there's a clause which says I have to put in a security deposit.
Yes.
This security deposit, a portion of it is in cash, and a substantial portion is by way of a bank guarantee. About 6 crores 9 lakhs by bank guarantee, 1 crore 72 by way of cash. I can't resile or run away from the fact that there was a default. The default being,
Mr. Mitra, use the microphone properly.
I'm sorry,
Yes.
the default being, when I wanted to put in the bank guarantee, my learned friends clients said no. The bank guarantee has to be put in by the special purpose vehicle with the concessionaire agreement has been made. The bank guarantee was put in by one of the constituents, both in 2016.
So you're the SPV?
I'm the SPV.
Yes.
There are two constituents who formed the SPV. In 2016, at the initial stage of the agreement, the first bank guarantee was also by one of the constituents. Now again, by the second constituent, which they had accepted, we had put in, but they refused to accept. So now what we have done, I think that should satisfy them completely. The entire amount has been put in by cash. There was a balance of 25 lakhs. We have put that today morning. The entire amount. I'll just show your lordship, once the clause of the concessionaire agreement.
You have put the balance cash today morning. What does that mean? By way of what? Bank guarantee?
No, cash.
Cash.
Yes.
And what is the balance?
Nothing remains.
What is the balance? How much have you put in?
609 94 844.
But I thought that is the award. That is the awarded amount. No?
Correct. That. There's an award amount. The concessionaire fee, I have to put in a portion of it by way of a security deposit. So that amount, 609 by bank guarantee, 172 by cash. This is the breakout. 172 cash I had already put. 609, I've put in the entire amount now by cash.
So the total amount is how much?
We're about 7 crore 82 and odd. 782 98 44. Entire amount I put in by cash. Would your lordship see the security?
So what is your prayer now? That they shouldn't terminate the concessionaire agreement?
The September 4 notice has to be stayed.
Show me the notice, please.
Yes. Kindly take page 402.
Four zero is a table.
No, 402, Millard. 402.
Yes, what are they stated here?
Yes, Millard. Kindly see, Millard. If you see, Millard, from paragraph 2, it may please be recalled that security deposit of Messrs. Welcome was appropriated in accordance with 7.2 of the Welcome Millard. Welcome Retail Millard is the SPV of the agreement due to non-payment of dues, which was occurrence of concessional event of default as per clause such. Subsequent to that, in compliance of 18.2A of the agreement, wide AI letter number such and such, Welcome was asked to recoup the security deposit amount as mandated under clause 7.1.1 of the agreement, dated 30th March 2017, within 15 days of issue of the letter, failing which necessary action to terminate the license in terms of the clause 19.1 of the agreement be initiated.
Yes.
Then, Millard, if you see the next, upon termination, Welcome shall hand over. Then, Millard, notice is issued without prejudice.
Where is the arbitration agreement?
Yes, my lord. Kindly take, my lord, the concessionaire agreement, which starts, my lord, at, my lord, page 263.
Page?
263. My lord, kindly take straight away to 313, which is, my lord, the arbitration clause, my lord. 22.2, my lord, at 313 is the arbitration clause. It's a two-tier arbitration, my lord.
Two-tier, what does that mean?
First, my lord, is a conciliation proceeding, which.
So all that is, no, it's a section 9. So it's a
Yes.
pre-reference.
My lord, what had happened, we have already gone through the conciliation process, it failed. Thereafter, my lord, the section 11, lordship had been pleased to appoint an arbitrator. Now, my lord, since the arbitrator has refused, my lord, to take, my lord, the reference.
I can't hear you.
Arbitrator has refused to take the reference, my lord. We are applying afresh, my lord. We don't have a.
No, so what happened? There's no arbitrator as of now. And when did the arbitration pause?
Pause. No, it never started, my lord.
Never started.
When we intimated him, he,
When was that?
I'll tell you, lordship. Kindly take, my lord. Lord, if you take my petition, my lord, I have pleaded that. Page 9. Sorry, my lord. Page 9, my lord, kindly take, my lord, of the petition. Para 20.
That's of 13 July,
Yes.
2023.
Yes. Sir.
Very well. Yes, Mr. Mukherjee.
And, just before Mr. Mukherjee starts, would your lordship want to see the security deposit clause once?
If it helps you.
Yes,
But
yes.
I'm
my lord.
not disputing that, you know.
Not,
You
not,
see,
yes,
was
yes, Mr.
not-
Mukherjee.
Our notice was not to, it was intended, not so that the security deposit which we had not appropriated for non-payment of the concession fee, not that is to be recouped. The balance has to be not maintained by them. They were trying to not maintain that balance through another entity, which we did not. Now that not the contracting party has not given this not the recoupment of the value. So far as the security deposit is concerned, my lord, I'm satisfied as of today. Now, my lord, so far as the rental portion is concerned of the concession fee, that is there in due of about my lord 6 crores and odd. But for that, my lord, I'm entitled to take any action under the agreement. But this is where it stands as
But
of today.
Mr. Mukherjee, what has been paid today morning then?
But that is not of the balance of not the security deposit. Now the
That's a
security
6.09.
Yes,
And now what remains according to you?
nothing.
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 So you will not take any steps?
So far as not the recoupment of the security deposit is concerned, not I'm not as of today.
Yes.
But so far as not the unpaid amount of the concession fee, not I'm entitled to.
And that is how much?
That is about not 6 crores and not exactly what the
That's not, my lord, the subject matter of the.
One minute, Mr. Mitra, you have to wait. Yes.
But I'm giving your lordship the exact figure.
No, and this unpaid amount of the concession fee, what you're saying, Mr. Mukherjee, that is part of the arbitration agreement.
Yes.
It
But
is.
they have to not pay the concession fee every month. They are
Yes.
the master concessionaire. They will not let out not the shops in the airport premises. They collect not rent from the small stallholders, pay to my client in a consolidated manner. In security, lot they have already made not the security deposit. Not I'm satisfied on that. But the rental portion is due. That is not part of the agreement. Therefore, if they fail in the rental portion, not I'm entitled to take steps against them.
Well,
But the amount is not almost 6 crores. Not
6 crores.
6 crores.
And show me the clause, the relevant clause, please, Mr. Mukherjee, which entitles you to take that step for the unpaid rental. 7?
I'll just but termination 19.1 for concessionaire event
give
of
me the
default
page,
at
please.
page not 306. Not I'm sorry. Not 306.
306.
Lodge.
Yes.
But clause number 19.1 termination for concessionaire event of default.
Yes. And which is the clause which Mr. Mitra is relying on the security deposit?
Deposit 7.11. 7.1 is at page, my lord,
277, my lord.
277.
Very well. Is that all, Mr. Mukherjee?
And Lord, kindly have a look at 8.2. That is not the license, that is not the concession fee portion, 8.2.1. Page 279.
8.2.1. How does
Yes,
that help you?
on consideration of the concession fee, this agreement and the covenants, warranties on the part of the concessionaire herein contained in accordance with the terms set forth herein, hereby grants the commencing access date such and such. This is not one of the condition, that payment of the concession fee, which they are in areas as of now.
And the termination is what you're relying on is 19.1.
Yes, or any of the default, there are multiple default clauses. Any of the default, and one is non-payment of the concession. One is also for non-recouping the security deposit, which they have done as of.
Very well.
May I just take one moment?
Yes,
sir?
yes, Mr. Mitra, what have you done? What do you propose to do about
Yes,
the
my lord,
concession fee?
I'll indicate. My lord, so far, concession fees have been paid. Kindly see once again the notice of 4th September. Doesn't talk about, my lord, the concession fee. It's limited, my lord, to security deposit. Kindly have a look, my lord. The entire tenor of the letter, my lord, is termination because of.
Yes, second paragraph.
Yes, my lord, non-recoupment of the security deposit. And I have, my lord, as on today, my lord friend has very fairly said, I have, my lord, satisfied that. Where is, my lord, the question, my lord, if I pose myself this query, the question of, my lord, terminating the agreement on the basis of non-payment of concession?
Very well. Mr. Mukherjee, what I will do is I will restrain you from taking any steps or giving further effect to 402.
Lordship, and they have to give a reply in terms of clause 4 of this page 402.
Clause 4?
Yes. They have
Yes, to make a
represent-
representation.
Yes, subject to that.
Yes.
I have already made that. It's on record. I'll make another one. If not, if it satisfies them, I'll make another.
Very well. The only dispute which, the only question which remains before the court after the petitioner, after the payment made by the petitioner of approximately rupees 6.09 crores in cash to the respondent today morning, is whether the respondent should be restrained from giving effect to a notice dated 4th September 2023. Stop. Next, the notice issued by the respondent dated 4th September 2023 to the petitioner threatens termination of the concession agreement, capitals, concession agreement dated 30th March 2017 in the event of non-recoupment, RECOUPMENT, non-recoupment of the security deposit mandated under clause 7.1.1 of the agreement, capital A. Stop. The notice goes on to demand vacant handover, goes on to demand handing over of vacant possession of the premises by the petitioner to the respondent in terms of the said concession, in terms of the said concession agreement. Stop. Next. Learned counsel appearing for the respondent, Airports Authority of India, Airports Authority of India, comma, submits that after payment of the 6 and odd crore by the petitioner today, comma, the petitioner has satisfied recouping of the security deposit amount in terms of clause 7.1 of the agreement, but that, however, the petitioner is still to deposit the concession fees as per the agreement. Stop. Council submits that clause 19.1 of the agreement entitles the respondent to terminate the agreement for recouping of concession fees, of the concession fees. Stop. Next. Upon considering the submissions made on behalf of the parties, comma, the impugned notice which the petitioner seeks, in terms of which the petitioner seeks a restraint on the respondent, comma, only speaks of, only mentions security deposit and calls upon the petitioner to recoup the security deposit amount under clause 7.1.1 of the agreement, of the concession agreement. Stop. The letter, the notice, which is in effect an intent to terminate the concession agreement, comma, does not mention anything about the petitioner being in default of the concession fee or otherwise. Stop. Next. Therefore, comma, this court is inclined to pass an interim order of protection in terms of the notice dated 4th September 2023. Stop. The respondent is restrained from taking any steps or acting in terms of the notice dated 4th September 2023. What remains of the AP? Stop. The needless to say, comma, the other dispute brought to the notice of the court does not form part of the notice and hence the present application. Stop. Next, Mr. Mukherjee, I will dispose the present case.
But let them give the representation in terms of clause 4.
Very well. Yes. The petitioner will be at, the petitioner shall give a representation to the respondent within the time mentioned, which is to be counted from today. Stop. Next, AP 668 of 2023 is accordingly disposed of in terms of the above.
I'm grateful.
Lord, just one thing, I'm very obliged. Your Lordship recorded that the payment was made today. It's only the last tranche of 25 lakhs which was made.
25 lakhs was paid today. Yeah, that covers not the
Yes, it
entire
covers the
amount.
entire thing, but I thought I should bring it to your Lordship.
हाँ, যেটা বললাম কি 6 point কি একটা বললাম of approximately rupees 25 lakhs হবে ওটা। Stop. The payment made is the payment made covers the total amount of rupees 6.09
09 crores.
6.09 crores.
Want the entire amount?
But I'm giving the figure, my lord.
No, 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 not required.
609.94.
Approximately.
Very,
Yes,
I'm very grateful. For that.
I'm grateful. my lord.
yes,
My lord,
Column
the
next.
AP stands disposed of.
yes,
Gotcha.
yes.
Item number 22, ITD CM joint venture.
This is that matter where the
Commercial division.
commercial and non-commercial has been going on for quite some time.
Yes,
Well,
yes, yes.
I want to,
Microphone, please,
your
Mr.
lordship,
Sen.
pray for your lordship's leave to file an affidavit just to take an exception to the report of the registrar original site. For the records, will not let it remain in your lordship's file because otherwise, my point, so that my point remains.
But I would like to be
Yes.
served with a
Yes,
copy
yes,
of this
definitely. That I
application and if necessary, deal with it also.
Yes, learned counsel appearing for the respondent who seeks, who objects to the matter being heard in the commercial division, comma, seeks to take an exception to the report filed by the registrar. Original site, report ta kothay? Dated 31st July 2023, stop. Let the affidavit is taken on record. Stop. A copy of the affidavit shall be filed on the petitioner. Stop.
I have served.
Mr. Bose, when do I keep the matter?
My lord kindly gives us 2 weeks' time, my lord, to look into the report. I do not know what technical
No,
objections.
not 2 weeks, Mr. Bose.
But
Come
my
back
lord
before
gives
the-
us in 1 week.
Yes, list this matter on 27 September 2023. Stop. The petitioner may use a reply in the meantime. Capital R.
Item number 23, Damodar Valley Corporation.
Lord, I beg to appear for DVC in the matter, my lord.
Yes.
Lord, your lordships have heard both parties extensively, my lord, and we have filed our notes, my lord.
I have
No.
some questions. Someone note that out. Mr. Kaur, I've made some notes, some questions you can also clarify after Mr. Kejriwal.
Yes.
Yes, you can write it down, Mr. Kejriwal. I'll just give you my questions and then you can answer. Why the agreement dated 30th April 2018 should be taken as a final agreement? Then how do the sittings of the arbitration held in Kolkata be helpful to any side, either you or Mr. Kaur? All right, whatever 29 sittings and then the rest of the sittings in virtual mode, on the virtual mode, etc. Then your argument with regard to section 42 read with 21E. How is that material? How is that relevant? And you had filed another note with some contract clauses. What is that?
No, those are only the clauses of the various contracts between the party, the NIT, the annual rate contract and the contract agreement.
Very well. Yes. Do you want to answer today or tomorrow?
My lord, we can, my lord.
Yes, yes. Tell me.
My lord, the first my lord, query that has fallen from your lordships, my lord, is that why is the agreement dated 30th April? Why should the agreement dated 30th April be considered as the
Because
final?
Mr. Kaur is relying on the other agreement. That's
My lord, both parties are ad idem on the point
no,
that
that I remember.
both-
Mr.
Yes.
Kejriwal, more or less, I've started dictating the judgment also.
My lord-
But that they have taken the point in the section 11 application, that I remember. What about the other point?
My lord,
Yes.
my lord, if I may just my lord, summarize, my lord, BLA is also admitting that this is the final agreement. Now, my lord, the only issue they raise is that the annual rate contract, the reason why they refer to the annual rate contract is because they say that the venue, which has been decided in the contract agreement of 30th April, cannot be read as the seat of the arbitration.
proceedings. And that is why they fall back, my lord, on the forum selection clause, which is contained in the annual rate contract, which says that South 24 Parganas will be the court having exclusive jurisdiction. My lord, to that, our submission has been that the court has to really see the arbitration agreement. And if the arbitration agreement has a venue decided and no contrary indicia to say that.
Mr. Kejriwal, sorry to interrupt you. I remember that argument, except that the agreement which Mr. Kaur is relying on of March, the earlier one, that also has an arbitration agreement.
Yes, my lord. And the reason why I say this is the final agreement is because the agreement itself says that any dispute arising out of this agreement or the annual rate contract shall be, my lord, dealt with in the clause which is contained in that agreement. And my lord, that arbitration agreement was relied upon in clause 11, the section 11.
That I remember. Which clause are you referring to? That
Clause
any
16 at page 52.
Yes, yes. That says that takes into account the annual rate contract as well.
That starts with the words that, my lord, any disputes arising out of this agreement or the annual rate contract.
Yes.
So, my lord, that takes care of the issue that this was the final agreement and the operative arbitration agreement, which also contains a venue selection.
Yes.
And, my lord, we fall back on the BGS SGS Soma judgment, which says, my lord, that relies on Balco as well
Yes,
as
yes.
Indus-
That part I've done.
My lord,
And
my lord,
yes.
why the sittings are important, my lord, is that the argument by BLA which has been made is that Kolkata as a city encompasses several courts and several jurisdictions. Now, the forum selection clause specifies South 24 Parganas as the jurisdiction. Therefore, the court should look at that and send the matter to the commercial court at Alipur or the commercial court at Asansol because the work was executed within the jurisdiction of the commercial court at Asansol. That is a submission, my lord. But my submission is that the venue which was selected was Kolkata. And the further, if I may say that further indicium that the parties intended this court to have jurisdiction is that all the physical sittings were held within the jurisdiction of this court, except for one. And of course, my lord, the virtual sittings, which were held only because of the convenience of the parties, because of the outbreak of COVID-19 pandemic. So, my lord, the dictum in BGS Soma, BGS.
The dictum of the Supreme Court, Mr. Kejriwal, sorry, you please continue after I finish, is that no contra indicium in BGS Soma.
Yes.
And followed by, what is that, India Mobile?
BBR India.
BBR is 2023.
IndusInd was earlier, my lord.
Indus Mobile. Indus Mobile. Yes.
Right, Indus Mobile was
BBR is
2017.
Justice Khanna.
Yes, my lord. Justice Khanna in 2022.
Yes.
So, my lord, the reason why the sittings become important is that shows that the parties intended that this court should have jurisdiction, and that is why all the physical sittings, barring one, was held within the jurisdiction of this honorable court. And, my lord, only when the COVID-19 outbreak happened, that is when the parties decided to hold all the meetings virtually.
Except that Mr. Kejriwal, that argument, or rather this argument, does not fit in with the seat and the venue argument, because venue is a matter of convenience. So whether parties sit in the Bar Library Club or whether the parties sit in some hotel or some other neutral venue, that is a different thing. That is venue. That is convenience. Your argument is of seat, which anchors the arbitration to a particular place. So how does that?
The reason is that if the venue has been declared to be a location which has perhaps multiple jurisdictions, then in order to, my lord, identify which particular court would have jurisdiction, there, my lord, my submission is that the location where the sittings were held and where they were intended to be held would perhaps, my lord, offer a contrary or a relevant indicium or indicia to show that this court was intended to be the seat of arbitration. But that is why the sittings become important, because all but one physical sitting was held within the jurisdiction of this court, and, my lord, the venue only said Kolkata. Now, my lord, if the argument is taken that Kolkata has multiple jurisdictions and multiple courts, then, my lord, to identify which court would the arbitration proceedings be anchored at would, my lord, in my submission, be indicated by the place where the arbitration sittings were actually held and where they were continued to be held.
When seat is not designated.
When seat is not designated. But even, my lord, the extended argument could be made would be that even if the seat was said to be Kolkata, the same argument could be made that Kolkata has many jurisdictions. Therefore, where would the court determine the seat to be really? Whether it would be my lord, the commercial court at Alipur or my lord, Rajarhat Commercial Court or this court. My lord. So my lord, then my submission is that the court would have to look at the factual matrix where the sittings were held to identify what the parties intended the seat to be.
Very well.
That is why, my lord, my submission is that the sittings become important.
Yes, yes. And what do you say about the 42 read with 21E?
My lord, Section 21E has been clarified, my lord, has been clarified by the judgment in Balco by the honorable five judges bench, saying that 21E cannot be read in a restricted manner to say that place where cause of action has arisen and would form the matter of a suit that.
So not a section 20 matter, not a section 20 of the CPC matter.
Not a section 20 of the CPC matter. And there, my lord, the courts have read 21E with section 20 to say that when there is complete freedom, party autonomy, then it cannot be restricted to say that if you choose a neutral seat, then the jurisdiction will still fall back on the cause of action under section 20 of the CPC. And my lord, section 42, my lord, we do not rely on section 42, my lord, because as we know, my lord, that section 11 is not going to restrict the jurisdiction under section 42 of the Arbitration and Conciliation Act. On the contrary, my lord, the judgment relied upon by the respondent, PLA, in the matter of my lord, Ravi Ranjan, my lord, the Ravi Ranjan developers judgment.
Yes.
That judgment, my lord, says that because the first proceedings were filed, my lord, in UP, therefore the seat would, under section 42, the parties would have to go back to that court.
This is the Faridabad. That one?
My lord, Faridabad, yes.
Yes.
That was the Ravi Ranjan developers judgment. My lord, that judgment.
And court said that it has to be Delhi. Or is the one?
No, this was Calcutta.
Very well. No, I saw something of Justice Nariman which says that Faridabad, but has to be.
That is
New Delhi.
BGS Soma. I'll read the.
Not BGS, that after BGS, short judgment, yes.
Brahmani River Pellets, perhaps.
Brahmani River Pellets is by Justice Bhanumati.
Yes.
Yes.
Even BGS Soma, I'll show my lord, that also says the arbitration shall be, the venue of the arbitration shall be at Faridabad / Delhi. And my lord, the court relied upon the sittings, the actual sittings having been held at Delhi to decide that Delhi would be the seat of arbitration, and that is what was my lord, evident from the action of the parties and the conduct of the parties. Therefore, my lord, section 42 read with section 21E and my lord, section 20. My submission is that the cause of action is not necessary when determining the seat of arbitrations, and the seat of arbitration can be a neutral venue where the arbitral proceedings would be anchored and the jurisdiction.
So you're not relying on 42?
No, my lord.
You're relying on 21E.
21E is read with section 20 as has been interpreted by the judgment in my lord, Balco, and thereafter in my lord, BGS Suma as well. So my lord, the submission of BLA, if I may my lord, summarize it.
No, not required, Mr.
So my lord, I hope, my lord, I have answered the question.
Yes. Thank you. Yes, Mr. Kaur, if you want to add to it.
But I have already made my submissions.
Yes.
So far as agreement is concerned.
No, just on my queries, that's all.
Yes, so far as the final agreement is concerned, Lord, it also, Lord, takes into account the earlier agreements that has been signed. And that agreement is very specific that not only clauses 1 to 19,
Yes.
but the annual rate contract will have to be read into the agreement. So, Lord, that's the party autonomy, which is, Lord, which must prevail, because, Lord, when the parties entered into the agreement, they entered into the agreement with their eyes open that not only the final agreement, clause 1 to 19, but, Lord, also the annual rate contract should be read as part of the agreement. It's bodily incorporated. On the second point, Lord, sittings held in Kolkata, Lord, really speaking, it has no, Lord, relevance to the matter, because, Lord, if the seat of arbitration is not mentioned, and, Lord, as stated in BGS Soma, that, Lord, seat venue has to be read as a seat where, Lord, all the sittings of arbitration is held, not only all the sittings, but also, Lord, the award is pronounced from that. Paragraph 82, I think, VJ Soma, I have read it out to your lordship.
Yes.
And that also, my lord, indicates that when the seat to be read as venue should be read as seat,
Yes.
there has to be some indications in the agreement. Then I have made my submissions on that. And my lord, 42, my lord, does not apply. That also, my lord, I have also made my submissions. And my lord, 21E is the definition is expanded by reading section 20 into it. That is what the judgment.
So you're on the cause of action.
I am only on the cause of action. And I am saying that, Lord, the parties had agreed that there is a chosen forum where the parties would go in case, Lord, the arbitration proceedings happens. So this is, Lord, in short.
Very good. Thank you. Thank you, Mr. Patil.
One more submission, my lord, I missed out, my lord. Although not argued orally, my lord, in the notes I found that, my lord, BLA has said that the dictum in BJ Soma as well as Indus Mobile is applicable only to international arbitration. However, my lord, in BBR India judgment of the Honorable Supreme Court, my lord, at paragraph 20, the Honorable Supreme Court has clarified.
No,
that
you're referring to paragraph 82 of BJ Soma, which talks of the supranational body of laws.
Also, my lord, paragraph 61 of BJ Soma
Yes,
says the same thing, that if only venue indicated, then that will be equivalent to seat. My lord, the argument of BLA in the notes, though not, my lord, argued orally, is that those principles apply to international arbitration and not to domestic arbitration as in the present case. My lord, paragraph 20 in the BBR India judgment, my lord, the Honorable Supreme Court clarifies that the principles enunciated in all those judgments are applicable to domestic arbitration as well. Paragraph 20.
The paragraph 15 of my note, your lordships will find I have given reasons why BJ Soma does not apply to our.
Yes, I've seen that. Paragraph 20, you said BBR.
Of BBR India.
Thank you. Thank you. Both Mr. Kaur and Mr. Kejriwal. Yes. Learned counsel appearing for the petitioner and the respondent have clarified a few of the queries of the court. Stop. List this matter on October 2023 under the heading for judgment.
Grateful.
Yes, yes. It is clarified that the judgment will be on GA number 2 of 2022, which is the respondent's application for return of the application for being presented to a proper court.
Grateful.
Item number 24, say equipment.
But my application, my lord, today, my lord, I'm praying for leave to, my lord, deposit the
And
5,000.
Mr. Dashgupta, I'm very sorry about your father. Yes. Yes.
My lord, in my section 34, my lord, I'll have to deposit the 5,000,
Yes.
5,000 court fees. I'm praying for liberty to do that, my lord. I need, my lord, 1 week's time, my lord. This was mentioned.
Yes.
But may I indicate only one thing?
Yes, yes. Mr. Dotto, microphone, please.
My lord, there is a NCLAT proceeding pending with regard to this, which is fixed sometime the first week of October. If your lordship,
NCLAT proceeding for what?
my lord, with regard to the dispute, with regard to their claim against our company.
So you are under CIRP?
I am under CIRP.
Yes.
My lord, the NCLAT is probably of the opinion that unless High Court decides on what is going on here, they would not take a decision. Either way, we are stuck. My lord, we require some sort of consideration from your lordship.
Consideration means what?
With regard to this AP. My lord, if your lordship grants us some precedence with regard to they are praying for a week's time to deposit that. I am.
Yes, yes, definitely.
Some precedence.
Yes. The learned counsel appearing for the petitioner seeks time to deposit the court fees as per a notification of October 2006. Stop. List this matter after list this matter on 25th September 2023. Stop. Next, learned counsel appearing for the respondent, comma, the award holder, comma, submits that, no, requests for some precedence in the matter on the ground that the respondent is presently under corporate insolvency proceedings which have been initiated by the petitioner against the respondent. Stop. Next, list is bolam ki? List is,
The leave may be granted, my lord, unless. the
yes,
leave is-
the petitioner is granted leave to take steps for deposit of the court fees.
They had filed an application, supplementary affidavit with regard to their section 34(2) application. And may I use the affidavit in opposition? And we have served copy, may I file?
Yes, the affidavit in opposition of the,
Supplementary affidavit.
the affidavit in opposition to the supplementary affidavit is taken on record.
Wait for that.
The affidavit in opposition of the award holder to the supplementary affidavit of the award debtor is taken on record.
Government of Maharashtra.
Yes.
Lordship, this matter was kept for filing
Yes,
notes
yes,
of
yes.
arguments. Notes of arguments are read. Lordship. So short notes of arguments, I have already assimilated all the judgments also, which have been discussed by both the parties.
Respondent, you are the respondent in,
I am the respondent in this AP.
you are
my
the
lord, and-
respondent.
Yes, my lord, and my lord, the applicant in the GA2.
No, no, short notes of arguments on behalf of the respondent. So this is your note.
Yes.
You have been, it's very unclear. How will the court understand? দেখাও তো কোনটা কি কার নোট এটা কেউ না yes you're the respondent in the AP.
And the applicant in GA2.
What is GA2?
So GA2 is an application for modification of your lordship's order dated 12 July 2023, my lord, whereby your lordship directed them to deposit, my lord, a sum of rupees 26 lakhs 25,000.
No, so you're asking for modification of the quantum.
Of the quantum, my lord. My claim is that is not, my lord, the 75% on the principal claim, and my lord, not even the 75% of the claim in principal plus interest.
Mr. Sinha, why is your note looking so rundown?
Your Lordship, it was
You
just-
were turning the pages constantly.
No, Your Lordship, actually, the thing is, it was there outside the brief and last time when we
It
presented
looks as if you have prepared your note 1 year back. Is that correct or not? No, not 1 year back.
The first page, Your Lordship, it was not on bond paper, so it is on complaint. The first page. I've taken the liberty to take all the judgments together for your benefit.
And how do you spell regard, Mr. Sinha?
RDGARDI.
দেখাও তো একটু correct it. You don't check it. Check the note, Mr. Sinha.
Checked, I missed this, Your Lordship.
You don't check the headings. You check the body.
No, my mistake. I have to guess.
Let me check if there are any other spelling mistakes. Very well. Yes, learned counsel appearing for the petitioner in AP 90 of 2023 and the respondent have handed up their respective notes. Also with regard to GA 2 of 2023, which is the application of the respondent in the AP for modification of an order passed by this court on, what is it, when did I pass that order?
12th July 2023.
On 12th July 2023. Stop. Next, list this matter on 28th September 2023. অন্যটা কবে রাখলাম দেখো?
Your Lordship, one thing, Your Lordship, just one.
One minute. Ah, 29th.
Your Lordship, only one thing, the notes for both the parties is only with respect to GA2, not with respect to the
Yes,
main
it is,
application.
yes. Next, it is clarified that the notes filed by the parties are only in respect of GA 2 of 2023.
Much of that.
29.
Apijut Sardar.
I am for the petitioner, my lord.
My lord, there is a section 34 application wherein I
Yes.
have taken the point of maintainability. Now, my lord, the maintainability on the ground of section 34(3) proviso. Award passed.
120 days.
Yes, beyond.
Or are you on the leave?
No, beyond one.
Yes.
Award passed in 2020, matter filed in section 34
Only give me
application
the date. Don't say 20. What is the date of the award?
21
Because it's a
September.
matter of calculation. How
Yes,
can you say
yes,
2020?
yes, my lord, I'm extremely sorry.
Yes,
21st of September 2020 is the
Yes.
date of the award.
yes.
This application has been filed on 10th of April 2023. From the application, it is shown that the award was delivered by the arbitrator on 20 October 2020, page 34 and 35. Now, my lord, when I took this point
Award delivered on the debtor.
on the debtors, who is the petitioner herein, one of the,
And that service is clear.
that service is clear. Now, my lord, the interesting point is that when this matter was taken up, this point was put before the court, my lord. My learned friend took a point that the PIN code mentioned in the award ends with 12, which is actually not his PIN code or his wife, rather their PIN code ends with 22. So from the agreement, I showed that the address that has been written down ends with the PIN code as 12.
Which page did you show that?
My lord, that my lord will get at page 73.
Yes.
And my lord, it ends with 7, the PIN code is 743412. Now, my lord, at the bottom, my lord will find that the signature of the borrowers are and the guarantors are there. So a specific question was put to me that who has handwritten this thing? And my lord has asked me to file an affidavit and on the other basis. This affidavit, last day, it was not affirmed. So my lord, allow me to file. I have served my learned friend. Now, my lord, from the affidavit, my lord, I have categorically stated that this form was though filled up by the officials of the respondent herein, but however, this information was derived from the documents submitted by them. And I have annexed those documents. My lord, kindly come to page 7 of my supplementary affidavit.
Have you served this on Mr. Mondal?
Yes, my lord. Last
Page-
Friday, my lord, after reminder, my lord, they have served, my lord. Because my
There
lord,
was
your
a
lordship-
delay, but
Mr. Mondal, don't tell me that's your best point. Yes, a page.
7 of my supplementary affidavit. This is
Yes.
the Election Commission of India voter identity card.
Yes.
My lord, at the middle portion, my lord will see that the PIN number that is given is 743412. My lord has got.
Middle portion.
Yes, my lord.
There are
Page
two
7.
boxes.
Oh,
Yes.
yes, page 7 here.
Yes, yes. Yes.
Now, my lord, kindly turns the page. The second page is his PAN card. And my lord, the page number 9, it's a bit unclear, but be that as it may, my lord, at the bottom, my lord will see that PIN number. This is an e-tax payment. PIN number given is 743412. And
Yes.
then, my lord, at page 10 is the passbook of the bank account of the petitioner, which also records, my lord, at the handwritten, my lord, we'll see SBI statement, Hafizur Sardar, his address, and the PIN number ends with 12743412. So, my lord, this was the document.
Passbook, which page is that?
My lord, page 10, my lord.
10. Yes. Yes.
So, my lord, and I have given the page 13. That is the respondent number 2, who is the wife of the petitioner.
Yes.
Rehana Khatun Sardar, my lord, same, my lord, voter identity card, and the PIN number says 743412. So this was the document they have submitted at the time of availing the loan, based which the addresses were filled up. Now, my lord, kindly comes to page number 34 and 35.
Of your affidavit?
Of my learned friend's application, section 34, extremely sorry, section 34 application.
Yes.
Page number 34 is what it says, item delivered to Rehana Khatun. On top right hand side, my lord will find delivery confirmed on 22 October 2020 at 9:54 AM. And just the page after, page 35, that is for Hafizur Sardar, who is the petitioner herein. Item delivery confirmed, same date. So, my lord, if my learned friends, this from the prima facie, it shows that my learned friend has filed this application beyond 120 days. And in terms of that, my lord, this application is not maintainable. So I was seeking for dismissal of
120 days would take you to
my
January,
lord,
January or February?
my lord, 120 days will take me to
February.
February.
Yes, Mr. Lal, Mr. Mundal, sorry.
My lord, in the affidavit, they have not.
Microphone, please.
My lord, in the affidavit, my lord, they have not disclosed what documents I have submitted. I have also submitted my Aadhaar card, the voter card and bank account in the year 2003, my lord. And 2014, Aadhaar card was issued, my lord. 2017, loan was issued. So, my lord, I filed an affidavit, my lord, ventilating, my lord, denying the affidavit of the supplementary affidavit, because, my lord, they have not disclosed my Aadhaar card, my lord, which was submitted by the petitioner, my lord. They have claimed all the documents. I have submitted that documents also, my lord, into the at the 2003, my lord. The
show me.
Yes, this is the Aadhaar card, my lord. Kindly see, my lord. Issued in 2014. Loan was issued, my lord.
How do I know it's been issued in 2014?
They are mentioning the date, my lord. In the I have, my lord, supply, my lord. Their date was mentioned, my lord.
Where is it mentioned?
Yes, my lord. Inside, my lord.
15th September 2014.
Yes, ma'am.
Yes.
These
Have you given this to Mr.
At the time of the loan was granted, my lord, in 2017. My lord, I have supplied all the documents, my lord. But they have not disclosed these documents, my lord.
And what is the pin code mentioned here?
22, my lord.
My lord, it mentions 74342.
And my lord, one more point, my lord. My lord, if your lordship kindly consider, my lord, the agreement, my lord. Award, my lord. Award, my lord, said, my lord, the agreement dated, my lord, April 2016. But appointment was on the basis of that agreement. But my agreement is 2017, my lord. 16th June 2017.
I can't understand what this is about service. When you got service of the award, I'm not hearing the 34.
Award said, my lord, no service was done, my lord. We kindly see the award, my lord. Award.
Very well. Yes, Mr. Go, what do you have to say about this Aadhaar card?
My lord, this Aadhaar card, I see that it is of 2014, my lord.
Yes.
But my lord, the documents which I have relied upon, all the document contains their signature. And my lord, those I see from the bank statement at page 10, the bank is issuing it on 4th April 2017 on right-hand side corner.
Where, which page?
Page 10 of my supplementary affidavit. So, my lord, knowing fully well they have given. And surprisingly, my lord, the award was also delivered.
No, where are you getting that date from?
Page 10, right-hand side.
Yes.
BP Pal.
Who is this person?
Must be, my lord, someone from the State Bank of India who has written it by his hand.
Yes.
So this is, all these documents were signed, countersigned by the petitioner.
Yes. The respondent was given, the only question before the court is whether the present application filed for setting aside of the award, of an impugned award, of an award dated 21st September 2020 is barred under section 34 within brackets 3 of the 1996 Act, read with the proviso thereto. Stop. Next, the award is of 10th April 2023. The award is of 21st September 2020. Stop. The delivery consignment report show that the award was delivered, shows that the item was delivered to the petitioners individually on 22nd October 2020 at 9.54.36 hours, 09 hours. Stop. Were delivered on the two respondents individually. Was delivered on the two respondents individually. Stop. Next, no, was delivered on the two petitioners individually.
Petitioner
Two
one,
petitioners.
he is also.
Next, the advocate on record of, you're the advocate on record?
No, madam.
Sorry, I'm sorry. Learned counsel appearing for the petitioners, however, takes a point that the delivery was effected on in the wrong address, which would be evident, comma, according to counsel, comma, from the PIN number in the documents provided by the petitioner to the respondent, petitioners to the respondent. Stop. Counsel relies on the Aadhaar card issued to the petitioner number 1 on 15th September 2014 to urge that the PIN number reflected therein is different from the PIN number in the address shown in the documents relied on by the respondent. Stop. Next, the loan agreement, now, contrary to the submissions made on behalf of the petitioners, comma, the loan agreement executed between the parties indicates the PIN numbers, PIN number 743412 for both the petitioners. Stop. The agreement has been signed by the petitioners. Stop. Even if this fact is not taken into account, comma, the supplementary affidavit of the respondent encloses photocopies of the documents furnished by the petitioners, including the identity card issued by the Election Commission of India, comma, the e-tax payment, e-tax payment, and the what is that, page 10? What is it?
Is a passbook, front page of the passbook.
And the front page of the passport,
Passbook.
a passbook, comma, all of which mention 743412. Mention the pin 743412. Page 10. দেখে নেবেন। Stop. The Aadhaar card, comma, which the petitioners say was issued after these documents in 2014, comma, loses relevance since the documents forming part of the supplementary affidavit of the respondent, particularly the e-passbook, particularly the passbook, shows that the document was issued on 21st April 2017. Stop. Next, the present application was filed on 10th April 2023. Stop. By all accounts, comma, the petitioners have missed the statutory time period under section 34 within brackets 3 read with the proviso, which provides for a mandatory outer limit of 120 days. Stop. Even if the court were to discount the leave under the proviso, the leave requirement under the proviso, comma, the present application is way out of the time period, way beyond the time period provided under the 1996 Act. Stop. At 34.3 যেখানে প্রথমবার বললাম, the Arbitration and Conciliation Act, comma, 1996 হবে. Stop. Next, AP 209 of 2023 is accordingly dismissed. Stop. There shall be no order as to costs. আর একটা লাইন লিখে রাখো, the last paragraph যেখানে বললাম না way out of time নাকি, তার আগে লিখে রাখো, the track reports also show that the item was delivered to R full stop Khatun, KH8UN, who happens to be the second respondent and is the wife of the first respondent.
First petitioner.
Is a wife of the first petitioner and is a wife of the petitioner. Next.
Item number 27 with 28.
The supplementary affidavit is taken on by the, yes.
Manoj, I appear for the respondent. We were supposed to file a supplementary affidavit, but Mr. Shivshankar Banerjee has not been able to finalize it due to his ill health. I was praying for ill health, my lord.
देखिए last order to
Let me cover this.
It's under what? This matter?
Section 34.
Section 34 million.
Both parties have
34.
filed section 34, 27 and
Yes,
20.
the respondent seeks further time. You want to prepare the volumes of documents,
My lord, actually it contains 12 volumes. and
seeks
there are-
further time to prepare the volumes of documents. Stop. The last order dated 11th August 2023 records a similar submission made on behalf of the respondent. Stop. Next. The time to file the volumes of documents, comma, as paid for, comma, is extended for a period of 2 weeks from date. Stop. The respondent shall pay costs of rupees blank to blank within 7 days from date. Stop. List this matter after 3 weeks.
Much
Next.
obliged.
Mission of Mercy Hospital. My application on section 34, that MSME, we've not served. University will also grant us the liberty to file a supplement.
Mission of Mercy is the MSME or Nihar is the MSME?
Nihar is the MSME.
So you're the buyer.
I'm the buyer.
Have you paid the 75%? No. Paid.
But I'll serve and come back and indicate. Otherwise, there'll not be a stay.
No, but
5%
section
we have a
19 of the
pay
MSME
that.
Act
We'll have to pay
says pre-deposit must be made in the event of appeal, challenge, whatever it is. Is it 19 or what? Something like that, 75%.
Your Lordship is absolutely right. This section 90.
Unless you're the supplier, I think there's an exception as well.
19, your Lordship is right. Here, I'm not the supplier. I'll just check.
So you have to pay the 75%.
I'm the buyer. To maintain this, I'll have to.
Yes, you have to pay it first. Before you file, before you challenge, that's the word of 19.
So I'll just serve in the meantime, and I'll have to make that payment and then.
Yes, when do you want to come back, Mr. Banerjee?
Lordship gives us 2 weeks.
Yes, this is an application for setting aside of an award passed by the MSME Facilitation Council on 27th February 2023. Stop. Next, learned counsel appearing for the petitioner, comma, who is not the supplier, comma, has a statutory requirement to pay 75% of the pre-challenge deposit under section 19 of the MSMED Act 2006. 2006. Stop. Next, list this matter after 2 weeks as prayed for. Stop. The petitioner will comply with the requirement of section 19 in the meantime. Have you served on the respondent or no? Yes, service also in the meantime.
Grateful.
Next.
Item number 30, concrete developer.
Comply with the requirement under section 19. Yes, yes.
This was that order
Yes, yes,
under
I
section
remember.
7. Actually, Mr. Mukherjee had last occasion, I was not there, but then he had explained that our suppression was not there. That we did not want to disclose the flat sale, that will be borne out from the minutes of the meetings that we had, that as and when they had come forward with their case of how many flats sold and we had explained. So on that, I mean, that of course does not turn on the, that's not a prejudicial fact, but that is not borne out from the minutes of the meeting. So the other most important fact, well, there are two points raised by Mr. Banerjee, are that this is not a case under section 25(4)
Of the LLP Act.
Of the LLP Act, that in case of a partner ceasing to be a partner, he should be entitled to his accumulated loss and profit, his accumulated profit and loss net figure.
Yes.
His case is, this is a continuation. So his case was that one of the heirs want to become a partner as per the LLP deed of the father. So if he becomes a partner at the time when the award is made, he should be put in the same position as if on the date of the demise of the father, the firm should be in the similar position so that he does not get a shell of an award. On that basis, though that's, of course, I will show that's not the basis of the learned arbitrator's order, but his submission was, on that basis, he had submitted that the day when the father died, that Pawan Chudiwal, there was certain flats unsold. And those flats were sold afterwards for rupees 34
odd crores. 34.
Mr. Mitru, the charge was, if I remember correctly, was not that you had suppressed in totality, but that you were disclosing in driblets. So when you were called upon to do so, you would come up with some other fact of a further sale.
That is what Mr. Mukherjee had shown.
Yes.
They had come forward originally in their application referring to 2 flat sales.
Yes.
So in our opposition, we had admitted that fact. Then in that case, thereafter, they had, by way of a supplementary affidavit, we had disclosed a flat which was registered in 2021, but the sale had happened in 19. The entire money had come in when the father was there. Only the registration that took place later. And similarly, there were thereafter they pointed out that 1 more flat was sold. To that also we had thereafter disclosed. Can we move on a moment? Number 1B.
Mr. Mitru, do you want to disclose some more fact of sale now?
No, well, that Mr. Mukherjee had done it. What he's just summarizing what he had submitted last year. 2 they had disclosed, we had confirmed. 2 thereafter, the arbitrator asked us to disclose any more. We had disclosed 2 more flat sales. Then they refer to 2 more registrations which took place after the father's demise. To that we showed those sales that happened during the father's lifetime. This is after affidavit. Yes. After that, they had.
Your, what is the confusion? When you disclose what? That is the confusion.
Mr. Mukherjee is confusing me, I must say. He had argued that, so I thought I would not be put questions on that part. So we had got ready on the other aspects, and Lordship's questions, I think he better answer that part, because that part he had argued a week back.
So you want to fob off the uncomfortable part?
No, that is the most comfortable. Logically, allow Mr. Mukherjee to summarize what he had submitted last year.
Altogether, 6 flats have been sold. So 6 flats were sold. 2 of the flats, they had disclosed in their petition only.
Very well. Mr. Mukherjee, don't have to pain yourself with that. I will take it, I will accept it that you have disclosed in phases. In tranches, rather.
In tranches. And the last document which they had disclosed, an exception to a supplementary affidavit. In that exception, they made out a case that 6 flats were sold and we have only disclosed 3. But that is not the case, my lord. The last 2 flats which have been sold, those were sold after we filed our supplementary affidavit. We could not have disclosed at all. And 2 other flats, my lord, which we had disclosed in driblets. Those were flats for which, my lord, the agreement for sale was executed prior to the death. Money was received prior to the death of Mr. Pawan Churiwal. That's why we had not disclosed it, because we were under the impression we are only to disclose the flats which are being sold after the death. So there was no suppression or disclosure.
So you did not get anything after the death of the father of the respondent?
After the death, my lord, only 2 flats have been sold. My lord, money has come after the death. Those were after filing of the supplementary affidavit, those were done. So therefore, we could not have disclosed at all.
Very.
Now coming to the core issue, what money came? Now coming to the core issue, what money came in? And
Mr. Mitru, you have to deal with that on the next day.
Very well.
You tell me when.
So I am here tomorrow, day after, whichever. Not sure. I am here.
Mr.
Except on
Banerjee?
Friday, second half. This is anyways.
Tomorrow, if it's possible, my lord,
Tomorrow, yes.
He's really in rejoinder now.
Yes, yes. Learned counsel appearing for the appellant will continue with his submissions tomorrow.
Grateful.
Mr. Banerjee, just 1 minute.
I'm sorry.
3rd October for judgment. Yes, Mr. Banerjee, just that DVC matter,
Yes.
please, ওটাকে third না, ওটা 28th রাখো, 28th হবে, record টা বলো। On the 28th, just be here in the DVC matter just to sum up the
Right.
arguments.
Right.
And please inform Mr. Kaur because
do that, my lord.
he
Immediately.
doesn't know that
I shall do that.
for judgment and just to sum up the
Very well.
arguments.
We'll do that.
And please, Mr. Kaur.
Yes, my lord, I shall do that immediately. 28th.
Non-commercial matter, item number 2, Prabhu Darshan Developers.
My lord.
Yes, sir. Um, the person who was appointed, the former judge of this court, who was appointed as the arbitrator by an order dated 5th September 2023, has subsequently declined to accept the appointment on health grounds. Stop. Next, blank is therefore appointed as the learned arbitrator in place and stead of the erstwhile person, of the erstwhile gentleman. Stop. The other parts of the order dated 5th September 2023 shall remain unchanged. What was the claim, Mr. Dotto?
13 crores.
13. 13.
13.
Yes.
13. Much obliged.
Item number 3, Rohitosh Kumar Kothari. Item 3,
My lord, I picked up here for the respondent, my lord. Here, my lord, the pertinent question that was raised, my lord, whether, my lord, an unstamped, unsigned arbitration agreement can be looked into, my lord. My lord, your lordship had directed the petitioners to kindly check paragraph 113 and 114 of NN Globals, my lord. Twice.
One appears for the petitioner. Stop. List this matter tomorrow as a last chance. Stop. A learned counsel appearing for the respondent will communicate this order on a learned counsel appearing for the petition.
You are pledged.
Yes, please tell Mr. Das.
Yes, my lord.
item 4, Prudent ARC Limited.
My lord, I am for the petitioner. Mr. Shotru Banerjee is appearing for the petitioner before your lordship, but he is not in court today. I am just praying for a not today.
Adjournment is prayed for on behalf of counsel appearing for the petitioner. This is matter on 25th September 2023.
Item number 5, Rajesh Shah and another.
Lordship, I appear on behalf of the respondent. I'm opposing the section 11 application.
First time.
No, your lordship, this appeared on 12th September. That day, your lordship, we didn't appear. Thereafter, after service, you're appearing for the first time, the respondents.
Yes, you were given one last chance to appear.
Yes, your lordship.
Yes, no one appears for the petitioner. List this matter tomorrow. Stop. You're the advocate on record or the counsel?
So I'm the counsel.
Learned counsel appearing for the respondent shall communicate this order on the petitioner. Next.
Item number 6, Sarika Booth.
My lord, I beg to appear for the petitioner, my lord.
Shall for the respondent.
Is my application under section 11 of the Arbitration and Conciliation
Can't
Act.
hear you. Yes.
My lord, is an application under section 11 of Arbitration and Conciliation Act. My lord, the petitioner is a home buyer. My lord, he has entered into an agreement with the developer on 7 September 2012. My lord, it was agreed that he will be handing over the possession within 36 months. My lord, which he failed to deliver the possession. My lord, we have sent them a notice under section 21. Thereafter, we have filed an application under section 11 for appointment of an arbitrator in 2016. My lord, they appeared before the honorable before this honorable court in the section 11 application, and they have the parties arrived at a settlement. My lord, the settlement is recorded in page number 61. My lord, thereafter it was withdrawn. The application under section 11 was withdrawn. My lord, subsequently, from time to time, it was agreed in the settlement agreement that they will be paying back the money within 5 months, 15 days. My lord, which they failed. My lord, subsequently, supplementary terms of settlement was executed between the parties on 6 occasions, extending the time. My lord, last agreement was entered into between the parties on 1st April 2019. My lord, in that agreement, they have tendered us a check of 87 lakhs, which we deposited. My lord, that check got dishonored. My lord, subsequently, we have sent a notice under section 21, claiming that amount, my lord. And they have replied, they have not disputed and denied our claim. They are not agreeing to our nominee. My lord, they have replied to our section 21 notice.
So at least show me the section
My
21,
lord.
show me the reply.
My lord, I am telling the facts, my lord. My lord, the section 21 notice is in page number 96, my lord. My lord, which they have replied on 24th August 2022. The reply is in page number 100.
Show me where you have invoked the arbitration clause. What is this?
My
You
lord,
don't know
the
how to argue a section 11.
My lord, the arbitration clause, my lord, in the first agreement, the arbitration clause, the first agreement starts in page number 19, my lord. My lord, the arbitration clause is in page 34. My lord, clause 18. My lord, the alternate dispute resolution in clause 18 is specifies the arbitration clause, my lord. My lord, subsequently, they have failed to give us the position. It was in clause 9.6 in page number. My lord, in clause 9, in page number 26, my lord. It was agreed that it will be handed over in 36 months. Which they failed, my lord, we have
9.6, where does it say 36 months?
My lord, the 9, I apologize, my lord, 9.5, my lord, completion date. My lord, the may I read, my lord? The construction, finishing and making of the said flat habitable and the parking space.
Where is the terms of settlement?
My lord, terms of settlement is in page number 55, my lord. This was executed on 29 September 2016. This agreement also has an arbitration clause, which is in page 60.
No, what is the agreement of 7 September 2012?
My lord, that's the first agreement which I have just shown, my lord. The first development agreement between the intending purchaser and the developer.
Where is the arbitration clause?
My lord, in the first agreement, my lord, is in page
You
number
just
34.
now said this one also has an arbitration
My lord,
clause.
page
Are you
number
not
60.
ready in the matter?
My lord, page number 60, my lord.
How is this clause different from the other clause?
My lord, it's same, my lord. It's connected. Both the agreements are connected. It's this agreement arises out of the first agreement which was executed between the parties. My lord, relying on these terms of settlement, my lord, in this next page number 61, the first section 11 which was filed, that was withdrawn, my lord, because the parties have arrived at a settlement.
What was withdrawn?
My lord, the application under section 11. The first application, my lord, the earlier application. My lord,
Yes,
the order is in page 61, my lord.
yes.
My lord, subsequently, they failed to make payment of whatever agreed between the parties, my lord. Thereafter, time to time, it was the subsequent agreement, supplementary memorandum of settlement was executed. And the last agreement, which was executed between the parties, my lord, on 1st April 2019, my lord, that is in page number 91. Page 91. Under the first paragraph itself reads, the supplementary memorandum of settlement is made on 1st day of April 2019, supplemented to the agreements dated 7 September 2012. It continued till 1st January 2019.
So what are all these dates?
My lord, all, on all these dates, my lord, the first agreement was on 7 September 2012.
Yes,
Subsequently, the terms of settlement is of 29 September 2016.
yes.
Subsequently, from time to time, it was extended. My lord, on 10th April 2017.
Extended into, for what?
For performance, my lord, for making payment of the money.
And what was the agreed amount of money which you were to get?
My lord, 87 lakhs. My lord, I have paid him 87 lakhs for getting possession of a flat. My lord, which they have not paid.
And you have not got possession till
My lord,
date?
have not got the possession, my lord. It was agreed, my lord, the agreement was terminated. It was agreed that they will pay back the money.
Yes.
My lord, my lord, they have handed over a check. My lord, is in page number 92, clause 2. My lord, the party of the first part being the developer have issued a post-dated check of a balance amount of 87 lakhs.
Yes.
5,000. My lord, we have deposited this check and it got dishonored, my lord.
Check of how much?
My lord, 87 lakhs. My lord, subsequently, we have sent them our notice under section 21 of the Arbitration Act.
Yes, where is that notice?
My lord, page number 96, my lord.
Yes, where have you invoked?
My lord, in paragraph number 13, my lord. Paragraph number 12, 13, my lord. My lord, paragraph number 12 reads, the said check was dishonored on 29th August 2019 owing to the refusal to make payment as per the memorandum of settlement.
Where have you invoked the arbitration clause? Can't you understand?
My lord, 13, my lord.
And they have not replied?
My lord, they have replied, my lord.
Yes.
Subsequently, they have replied in page, their reply is in page number 100, my lord. My lord, in their reply, my lord kindly takes up paragraph number 4. Here merely challenging the unilateral appointment, my lord. Relying upon the judgment passed by the Supreme Court in Eastman Perkins.
Very well. Yes, what do you have to say?
If your lordship kindly sees, your lordship, the
Microphone, please.
notice invoking arbitration clause at page 96.
Yes.
Lordship, kindly see the subject, your lordship, he has invoked the arbitration clauses in all the agreements. Page 96, subject, notice under section 21 of the Arbitration and Conciliation Act invoking the arbitration for resolution of the dispute arising out of the agreement dated 7 September 2012, 29 September 2016, 10th April 2017, 9 November 2017, and thereafter, your lordship, the agreement stated. 7 September 2012, your lordship, is the agreement to sale.
Yes.
Which is unregistered and unstamped. Your lordship, the arbitration clause, your lordship, is contained in that. Thereafter, your lordship, which I was expecting your lordship, the adversary will argue that this was actually superseded by the next arbitration clause. Lordship, that is, your lordship, the 29th September 2016, that is at page 55.
Yes.
But your lordship, that is not his case. He has invoked, your lordship, arbitration clauses. In all the
Mr. Sengupta, I will appoint an arbitrator. You choose which agreement you want to come under.
lordship, that they have to say, because there are multiple agreements.
My lord,
You have invoked all of them in your 21.
my lord.
Then which one?
My lord, the terms of settlement, my lord, which was filed before this court, my lord, the agreement on 29th September 2016, which is in page number 55.
Where does it say that they have, where is the payment clause under this?
My lord, 2A, my lord, in page number 58. My lord, 2A. My lord, the 2A reads, in the first place, the developer of the first developer, that is a party of the first part, shall make every effort to sell the aforesaid plat to the new buyer at such and such.
Show me how much they have to pay,
My lord,
please.
96, my lord, in the last sentence, my lord, 96,000, 96 lakh 99,000.
No, but you said 86 lakhs or something.
My lord, subsequently, they have made some part payment, my lord, and it was reduced, and right now, the principal amount which is outstanding is 87 lakhs, my lord.
Why don't you go and get this document stamped? The parent agreement. You don't want to do that?
I need to take instruction on that regarding that.
Your Chaudhary. Mr. Chaudhary, you were not ready on the last day. Today you should have been ready. You took time because you were not ready.
No, my
Then-
lord, I have not taken time in this matter.
The order records
My lord,
for the respondent takes
yes,
time.
by-
Sorry, I'm
by-
sorry.
My lord,
What instructions will you take?
whether they want to invoke the arbitration clause contained in the agreement dated agreement of the year 2012, my lord.
But each of the settlement agreements have an arbitration clause.
My lord,
No, that is what your 21 notice says. That's why I'm asking you.
my lord, it's supplementary, is connected agreement. It arises out of the main two agreement which was executed between the parties on 20.
Mr. Chaudhary, you don't know what a section 21 is, that you invoke that's the commencement of proceedings.
My lord, there's no.
So what about the other agreements? You have mentioned 7-8 agreements in your 21. Then
My lord, the arbitration clause is not there in the other agreements, my lord. It's supplemental to
the lawyer has written the letter.
my lord.
So the lawyer does not know that these agreements will have to have arbitration clauses. I'm keeping this matter tomorrow. Come back. Yes, it is now the turn of learned counsel opinion for the petitioner to take time for instructions. Stop list this matter tomorrow. Next.
Item number 7, Bharat Petroleum Corporation. Item number 7.
The first time. No one appears for the petitioner. List this matter after a fortnight. Next.
Item 8, Manojit Bhattacharya.
Lordship, Mr. Supratim Laha is appearing on behalf of the respondent. He is under the weather and has left the court.
He's what?
Under the weather and has left the court.
Under the weather. What does it mean?
He is not feeling well.
Is that what he told you to tell the court?
For he was feverish. That is what he has suddenly felt fever and has left the court.
List this matter after a week as prayed for. This is a 11.
Section 11.
Tell me when it is convenient for you. Tomorrow? Yes, list this matter tomorrow. Stop. Adjournment is prayed for on behalf of counsel appearing for the respondent. Next.
Item number 9, basement sales promotion.
Please, Your Lordship, this is my section 11 application. This service has been effected on 11 September at the registered office, 13 September at the dealing branch office. But I'm slightly.
Where? Not in Kolkata?
Not in Kolkata, the registered office is in Ahmedabad and the branch office is in Pune. But I have my copy of the affidavit of service, but I'm still being affirmed, if Your Lordship.
No,
please.
tell me, Mr. Thakkar, when you want to come back?
Tomorrow, I can come back tomorrow.
No, but they have to be here. If they're in Pune and Ahmedabad, and you're saying 11th September.
11th and 13th.
So tomorrow will be 19th.
Yes, my lord.
Come back day after.
Please, my lord. I'll give them fresh
Yes,
notice.
learned counsel opinion for the petitioner seeks time on the ground of the affidavit of service not being affirmed. Not being affirmed. Stop. List this matter on 20th September 2023. Stop, the advocate on record of the petitioner shall communicate this order on the respondents by 10:30 a.m. tomorrow.
Please wait.
And Mr. Thakkar, please don't send a mail, all right?
Then it might, 23rd, my lord, is reached 18th. Should wait.
Yes, next.
Item number 10, Messrs. US Infra Developers. Not a section 11 application.
Yes.
Lord, the arbitration clause, my lord, is at page, it's a development agreement. The arbitration clause is at page 32.
Mr. Jain, are you going to say there's no dispute?
No, my lord, there's no live dispute.
Yes, yes, this is a matter which I'd heard.
My lord, they had initially.
3 points
filed-
taken.
Yes, but the my lord, the fresh application. They had withdrawn the earlier section 11.
This is a new one. Very well. Yes, Mr. Chaudhary.
Yes, my lord, arbitration agreement is admitted, clause 28 at page 32. Now, my lord, on the only objection which I perceive coming, my lord, on live disputes, Lord, please take the section 21 notice at page 367. Lord, starts at, I'm sorry, my lord, it starts at 366 and Lord, it section page 370, my lord, indicates that we've invoked the arbitration agreement dated 12th November 2011, nominated an arbitrator, and have requested that this should be treated as a notice under section 21. Your receipt, my lord, should not be disputed because they've replied to the notice at page 381.
Yes.
Lord, at page 382, second paragraph, in the facts and circumstances aforesaid, my clients state that there is no arbitrable dispute existing between your client and my clients, which can be resolved by way of arbitration. The development agreement dated 12th November 2011, which is the fulcrum of your purported notice, was cancelled, terminated, and rescinded by my clients on 12th February 2019. Now, my lord, 12th February 2019 is at page 141. So, the argument is that after termination, there's 3 years have gone by, so therefore nothing can be referred to arbitration. Please, my lord, see page 141. This is the termination notice. 12th February 2019.
Yes.
This is followed by revocation of the power of attorney at page 144.
Mr. Chaudhary, I don't know what the matter is. What is the, what are,
This is, I'm sorry, but this is a development agreement.
yes.
Disputes, my lord, arose between I'm the developer, my learned friends clients are the landowners. Disputes arose in respect of the development agreement. There are other litigations. In a section 11, I don't really need to go into it. My case is that it's been wrongfully terminated. I don't accept the termination. My learned friend's case in
So the landowner has terminated.
Yes. My learned friend's case is that the termination precedes 3 years from the section 21 notice. So therefore it's barred by limitation, no live disputes. Page 141.
Oh, Nautel, the second part of Nautel.
Yes. That's not, he would have to come under that. And I would humbly submit that after the termination notice, he's waived the termination in writing by 2 specific documents. One is he's entered into an agreement, which is at page 302, which is in volume 3. 12th February 2019 is the termination notice.
The agreement for sale is 19th March 2020. It's a registered document.
1 minute. Termination notices.
12th February 2019. And this is what he uses in his reply to my
And
section
termination,
21.
1 minute, sorry.
Yes.
Termination notices.
Page 141. 12th of
Yes, yes,
February
yes.
2019.
Yes.
And
Yes.
this is referred to in his reply to section 21 notice at page 381, which I have shown your lordship that he says that since it's before 3 years from section 21, so therefore can't be referred. Now, my lord, I want to show your lordship page 302, 19th March 2020. This is an agreement for sale, a registered document. Now, please have a look at page 310.
Yes.
The purchaser had approached the developer for purchasing a particular flat.
You're looking at the last paragraph?
Yes, my lord. 310, subparagraph S, last paragraph. And before that, subparagraph R, which is partially, my lord, illegible. In terms of the said development agreement, such and such, the developer confirming party hereby and herein obtained a building plan, etc. Then purchaser approached the developer, then T at page 311.
No, purchaser is not, Mr. Jain is a landowner, you say.
Yes, he's the landowner.
And who's a purchaser?
And he's a confirming party to this agreement.
Who's the purchaser?
But the third party, my lord,
Third party.
purchaser.
Yes.
He's my lord, Shumon Ojha at page 306. Now, my lord, Mr. Jain's client is a confirming party to this document. And at page 311, he affirms the rights of the developer. At page 310, he mentions of the development agreement and says that the development is in terms of the development
No,
agreement
this agreement is between you, Mr. Jain, and who else?
and the purchaser,
Very good.
landowner.
Yes, how does it help you, Mr.
Not because at page 310
Yes.
and 311, all the parties to this document affirm the development agreement and act in pursuance thereto. Now, at page 310, subparagraph R, the development agreement is, my lord, referred to. And it is mentioned that the construction is in terms of the building plan, which is in terms of the development agreement. And then, my lord, subparagraph T, on or before execution of this agreement, purchaser has seen and examined the title of the developer and the right title and interest of the developer to sell the said flat, and the purchaser is satisfied. So my right to sell the flat arises out of a live development agreement. So when, my lord, the confirming party, which is Mr. Jain's client, signs and confirms that the development agreement is alive, he necessarily, my lord, waives the earlier termination. So therefore, the
So
termination.
this is only on the answer on to the point of there not being a live dispute.
Disputes there are, my lord, plenty. That's, my lord. And then there's another document, my lord, at page 298, which is a demarcation document, which is a
No,
right.
so Mr. Chaudhary, let me understand. What today is your claim? What is your claim today?
I claim specific performance of the development agreement.
Specific performance of the development agreement. And you need an arbitrator to do what?
My lord, to award, my lord, specific performance.
And
So I
what would be your monetary claim because of the fact that the agreement was not performed?
My lord, we will claim specific performance and, my lord, some damages in addition to specific performance under section 21 of the Specific Relief Act. Because my money has been, my lord, locked in the development and he's been obstructing, my lord.
What is that? What is the claim? Amount of claim,
But,
roughly? Rough estimate?
A few crores, my lord. Maybe
Few
two
crores.
2.5 crores, not more than that. But it's not.
That's your claim for? damages.
Damages in addition to specific performance under section 21.
Very well. Yes, your next point.
My lord, the other document I wanted to show was, my lord, page 298, which is the first page of volume 3. This is, my lord, a minutes of meeting which record demarcation of what is the developer's share and what is, my lord, the owner's share. Lord, please, my lord, see the signatures at page 301.
What is the date?
My lord, there's no date mentioned on the agreement, but the stamp paper, my lord, is purchased on 12th of September 2019, which your lordship would find at page 299. So it has to be, my lord, after 12th September, 12th February. 12th September, why are you confusing? 12th, it has to be after 12th September 2019. The termination is 4th of February. So both these, apart from this, conduct of
Termination is 4th of,
no, my lord, termination is
for termination is 12th
12th of
September.
February
No, 12th February
February.
2019.
2019.
Yes.
And my lord, page 299 shows, my lord, this demarcation document is on or after 12th of September 2019, which is the date of issuance of the stamp paper. So therefore, again, my lord, termination is waived. So owners have, my lord, affirmatively acted upon the development agreement within 3 years from the section 21 notice. Rest, my lord, if my learned friend, my lord, says it's barred by limitation, it's not, my lord, an ex facie bar.
So paragraph 45 of NOTEL.
And now there is a new one, my lord, which we've.
TNAG.
Yes.
TNAG is against you. Justice Pardiwala.
Yes.
Not against you.
No, no. Yeah, against bullshit. My money, my name. My lord, NOTEL is referred to in paragraph 47. Fifth line, my lord. Fourth line. The court undertook a comprehensive analysis of the relevant provisions and held that in cases where claims are ex facie time barred, the court may refuse to make a reference under section 11.
1 minute. Which page is this?
Sir, this is page 16 of the print.
Too many repeated paragraph numbers. Page 16.
Page
Yes.
16 of the print, my lord, it's page 47, paragraph 47.
Yes, yes. Yes.
In BSNL versus NOTEL Networks India Private Limited, this court undertook a comprehensive analysis of the relevant provisions and held that in cases where claims are ex facie time barred, the court may refuse to make a reference under section 11 of the Act of 96. This decision assumes importance and we should look into the same in little details. The appellant BSNL issued a tender notification inviting bids for planning, engineering, supply, such and such. And on completion, appellant withheld. Then, my lord, claim is made and argument of the parties. Now, my lord, paragraph 53, the following two questions fell for consideration of this court. The period of limitation for filing an application under section 11 of the Act of 96. And two, whether the court may decline to make the reference under section 11, where the claims are ex facie time barred. This court observed that the Act of 1996 has been framed for expeditious resolution of disputes, and various provisions have been incorporated in the Act 1996 to ensure that the arbitral proceedings are conducted in a time-bound manner. The Act of 1996 does not prescribe any time period for filing an application under section 11(6). Since there is no provision in the Act of 1996 specifying period of limitation for filing an application under section 11, one would have to take recourse to the Act of 1963 as per section 43 of the Act of 96, which provides that limitation act shall apply to arbitrators and applies to proceedings in court. Since
Very well. Tell me.
137. So that's my lord for filing an application. In my case, it doesn't, my lord, really
It's
come up.
these kinds of applications, Mr. Chaudhary, is Article 55 and 137.
Yes, and 137 is my section 21 notice, 3 years. And then also, my lord, 137, I can come and pay for condonation. I mean, in any case, 3 years, so till 2026, I can come. Now, the other thing is on the subject matter of the arbitration. There, my lord, general law applies.
So there are two things. Either the 21 notice is delayed or the substantive claims are barred.
Yes. Or Lord,
you're
or the
coming under which-
application is delayed. Section 11 application is delayed or the substantive.
Yes.
claims are
So which one are you coming under according to Mr. Jain?
My lord, the first one.
First one.
First one, the claims are barred.
So you're admitting that the that the substantive claims are barred.
No, my lord, I am showing that if I didn't have a case of waiver, I would have ended up admitting it. Because when I moved the section 9 application, we hadn't included these facts. So on the first day, Mr. Jain was not successful in ensuring I didn't get an ad interim order on the question of limitation. But we have come back, my lord, stronger, if I may say so. In the
By some more delay.
No, with some more delay, we found, my lord, some documents which, my lord, have the effect of helping me to show that, my lord, the termination was waived. So I'm absolutely within the time period.
So you have passed that mark by a whisker of how many days?
My lord, this
3 years?
September 19 and oh, Lord, I'll just tell your lordship.
By 4 days.
Copies of, no, my lord, this is the one, 19, no, this is 19 March 2020. The first one, my lord, is March 2020. That's, my lord, one example of waiver. The other one is September 19.
So 4 days versus 7 days.
Oh, yes. In writing, yes, your lordship is right. So just apart from that, I can always plead, my lord, that he's not waived his rights. And that also gets to go to limitation unless your lordship finds that it's absolutely bogus. Explicit time.
So what will you go to arbitration with? Your termination?
No, I'm going to show that his termination was wrongful. He waived it by thereafter acting in terms of the agreement, actively selling flats along with me. And now he is wrongfully refusing to perform the agreement. So he has to specifically perform the agreement. And by his acts of mischief, he's going to, the damage he has caused me, he's going to compensate me for that. This is my claim. And I get through because he says that termination notice and your section 21 notice, there's more than a 3-year gap. I am showing that no, termination is waived by you by executing 2 documents which are effectively within.
So you want to leave the learned arbitrator head scratching as to what to make figure out of the statement of claim.
I shall organize it, my lord, for the learned arbitrator. That after all, he is to give an award.
Mr. Jain, if the matter has waited for more than 3 years, according to you, you can wait for 1 day to give your reply
Lord, I am ready. If lordship wants it. My lord wants to keep it tomorrow. My lord, I can.
tomorrow. Yes. A learned counsel appearing for the petitioner, who seeks appointment of an arbitrator, has made his preliminary submissions. Stop. Next, learned counsel appearing for the respondent objects to the appointment on the ground that there is no existing live dispute between the parties. Stop. Next, list this matter tomorrow.
Great.
And Mr. Chaudhary, you do something, please. Just give me a 1 page of the dates so that you yourself also come to know what those dates are.
May I even try to come with a list of dates? Please?
Not required.
I shall give you. Great.
Item number 11, VKM Projects Private Limited.
That I'm for the petitioner. This is
Chief,
my section 11 application.
Lordship, I am for the respondent.
I must make a confession
before my learned friend.
No, your learned friend also wants to make a confession. What is your confession?
Lordship, this is the partnership firm. All partners stay in the Chennai, my lord. I need some time to file the Bhogadnama and appearance. I just instruct to appear before your lordship to just got the beep and
My lord,
kindly give me
this
2
has
weeks
been-
time. I will file
No,
the.
no, what 2 weeks time to file Vakalatnama? By Wednesday, file the Vakalatnama.
the arbitration clause is contained in a joint venture agreement. The claim is in excess of 50 lakhs. This ought to have been filed in the commercial division. It's come up before my lords. My lord, if your lordship may kindly direct the matter to appear as a commercial.
Where are you getting the 50 lakhs from?
My lord, in the section 21 notice.
You have made it. Show me
Yes.
the page, please.
My lord, your lordship will take page 70, just a moment, my lord. Page 86, my lord. It's a tripartite agreement where two parties are the petitioners claiming against.
So where have you said 50 lakhs?
My lord, at page
Mr. Lakmani, if that is the your most fundamental submission as of today, you should have known the page, which paragraph.
my lord, page 90, if your lordship takes one of the notice.
Mr. Lakmani, no, you cannot get ready in court. You have to get ready before court before you do the matter. Yes,
My lord, if your lordship takes page 80, I'm so sorry. my lord. Page 77 is where the notice starts, my lord. If your lordship kindly takes page 80 and the second last paragraph at page 80, my lord. As per our knowledge, of approx 5 crore has been paid to you by Rapiscan Systems according to clause 2 of the above mentioned supplementary
very
JV.
well. One of the notices sent by the petitioner to the respondent shows that the petitioner has a claim of approximately rupees 50 lakhs, 50 lakhs. Stop. This matter hence should have been filed in the commercial division of this court. Stop. The department is directed to take steps accordingly. Stop. The parties shall be at liberty of mentioning the matter for inclusion. Stop. Next, the respondent will file its Vakalatnama, the advocate, you're the advocate on record. The advocate on record for the respondents will file the Vakalatnama within 7 days from date.
My lord, may my affidavit of service be taken on record?
The affidavit of service is kept on record.
So, I'm sorry, my lord.
Item number 12, Acharya.
Madam, I am the petitioner, my lord. I could not complete the service, my lord. The respondents are probably deliberately avoiding service. This has happened also with the section.
In all your matters, it happens. What do you say?
My lord, this matter, my lord, even in respect of the section 21 notice, we had tried to serve them. It was returned. We had served.
Very
them.
well. How much time do you want?
One week's time, my lord.
Yes, list this matter after a week as prayed for. On behalf of the petitioner. Next.
Item number 13, Ritesh Agarwal.
I am for the petitioner, my lord. This is section 36(2) application, my lord, first day of operation of the award, my lord.
Affidavit of service.
They have been served, they have also been appearing in the matter, my lord.
Yes.
That-
What is your, how much is the awarded amount?
It is 12 lakhs and odd, my lord.
Show me the page.
At page, my lord, 24. Some totaling, my lord, to sum of rupees. If my lord,
Where do I get the amount? It's not mentioned.
they have, it has been segregated in 2 claims, my lord.
Where will I get the total amount? Awarded amount?
I did, my case is that, my lord, that I have not been served with any notice, even section 21 notice, and
That's a
thereafter the
different thing. That's a 34 argument. How you have to secure the amount. What is the total amount?
I'm praying for unconditional stay, my lord.
For the asking, I will dismiss it with costs. You will have to pay the exact amount that has been awarded against you.
That the fraud have been perpetrated, my lord. Yes, my lord.
Let me direct you to pay costs for the exact same amount.
My lord, I am the debtor, my lord, in this.
Mr. Dwivedi, are you not familiar with 36(3) second proviso?
Yes, my lord. The award has been made by perpetrating fraud, my lord. That is my entire case in 36(2), my lord.
Are you going to argue the matter?
Yes, my lord.
You are?
Yes.
Have you read the provision with regard to fraud?
Yes, my lord.
What does it say?
Even my lord, I'm relying upon the judgment of the
Mr.
Satyam
Dwivedi,
computers, my lord.
if you show judgments without telling me the facts, I will impose
I
costs
will
on
not-
you personally as a counsel for wasting the court's time. You think you come to the court and say, I want unconditional stay, and the court says very well.
Where certain facts are required to be indicated, my lord. If my lord,
So tell me, have you read the provision or not?
yes, my lord.
What does the provision say?
Lord, the provision says, my lord, if the award has been induced by fraud, my lord, the making of the award has been induced by fraud, my lord, then it is liable to be stay.
Is that the only condition under the second proviso?
By or before the arbitrator, my lord, that is
the condition in the second proviso.
yes,
Learned
my lord.
counsel is
Lord,
clearly not ready in the matter. Stop counsel is expected to at least read the provision before seeking unconditional stay of the award. List this matter when?
Let tomorrow, my lord. If my lord says.
List this matter after a week. Next. I am shocked. You are coming to the court without even reading the provision. You're looking at the book while you're making arguments.
My lord, the only point I'm going to argue, my lord, that is the award has been induced by.
I will dismiss it, secure the award, and I will give you a stay today itself. I'm telling you, I will dismiss it. Even before you start arguing, I'm telling you, I will dismiss it, but I will allow stay if you secure the amount. I can see that it doesn't warrant unconditional award, unconditional stay from the very facts. Next.
There are facts, my lord. I will come, my lord.
Next.
Item number 14, Art Parallel Iron and Steel Private Limited.
In my application under section 36,
Ma'am, for the
seeking
respondent.
conditional stay of an award dated 30th April 2018, passed by a sole arbitrator, Honorable Justice.
What is the awarded amount?
Awarded amount is approximately 25 crores.
Show me the award, please.
I'll show you the award. The award starts at page 23 of the section 36 application, and the awarded amount is at page 52.
52?
Yes.
What is the total amount?
It's approximately 25 crores.
Where do I get that amount? 25 crores? Not mentioned.
Not mentioned in the award. But it is under different heads. Principal is 10.
So there is no total amount given in the award.
In the award, it has not been categorically stated. It is unfortunate.
Unfortunate.
Page 50 is the principal amount your lordships will get. Last paragraph, page 50. At the bottom.
So what is the principal sum?
Principal is 10 crore 15 lakhs 89,526, which is also appearing at page 52.
So you should have done the math and come. If page 52 says something else and has included all these other heads, what is the total amount?
I have, if I may, my lord, I have brought
Yes. I don't know what kind of bar library complete. You just sit around the court, chat, but don't get ready in the matters. Very sad comment on the lawyers. Just sit around, chat, but will not get ready in the matters. This is the total amount, 24 crores.
Yes.
Yes, how will you secure it? Give a page to, give a copy to your learned friend, please.
Yes.
How will you secure it?
We'll secure it by way of bank guarantee.
50% by cash. So it's 24 crores, 41 lakhs, 92,237.
12 crores approximately in cash and 12 crores by way of bank.
So that is 24 crores. And what about the balance?
That also will secure.
So 12 crores by bank guarantee, remaining by cash.
Well, if the principal may be by way of cash and remaining by way of bank guarantee.
The principal is at page 50.
52, my lords, and 50 also. Particular number 1, my lords, at the top. Principal sum awarded to the claimant.
Yes, what do you say, Mr. Dev?
My lord, the first serial number is the principal sum. My lord, so far as third serial number is concerned, my lord, that interest was quantified by the honorable arbitrator, my lord. And the 4A and 4B.
No. What do you have to say to what your learned friend is saying, that only the principal amount by way of cash? That is what he's saying.
My instruction is, my lord, cash security, I leave it to your lordship. Now, my lord, only thing, my lord, if it's a bank guarantee, it, my lord, maybe by way of a nationalized money, of a nationalized bank.
Definitely. You don't expect the court to give you a bank guarantee of some of the petitioners who appear before the court in arbitration matters? And if you take out 10, 15, then how much is the remaining, Mr. Dev? If you take out the principal sum, then how much is the remaining?
May I give the exact amount, madam? Just it's 14 crores, 26 lakh, 2,711.
14 crores, 26 lakhs, 2,711.
Yes.
Yes, the petitioner / award debtor seeks stay of an award passed by a learned sole arbitrator on 30th April 2018. Stop. Have you filed a 34?
Yes.
When?
It's in the year 2018, but it's within the period of 19.
2018, and that has not been heard till date.
It is numbered as AP 366 of 2018. And it is
I'm giving you leave to withdraw the amount by today's order.
My execution is pending, my lord, and this.
I'm giving you leave to withdraw this amount. You don't need to make an application.
But also, my lord, the point of maintainability, because my submission was, it was filed after 120 days, my lord, in section 34.
The 34?
Yes, madam.
But that has not been taken up for hearing
for
from 2018. Why did you not mention for listing of the matter before whichever court?
I was proceeding with my execution application, madam.
No, my lord, they have not proceeded subject to correction. My lord, it
There
was
was a-
filed in the year 2018, but it has been reignited after a long hiatus of 5 years in this year, my lord, in the year 2013, and it has been fixed as a specially assigned matter.
So you are seeking stay of the award after 5 years from the date of the award?
Yes.
After 5 years?
My lord, I'll just indicate, my lord, there was a stay of the
Yes,
award.
you can withdraw the amount. I'm giving you that liberty. Yes, ki bola? Seek stay of an award passed by a learned sole arbitrator on 30th April 2018. Stop. The particulars of the sums awarded does not contain a total amount, but contains various amounts under various heads. Stop. The only clarity is of the principal sum being rupees 10,15,89,526. Stop. Page 52. Stop. Next. The full stop. The total amounts to the total amount awarded along with interest for various segments of period is rupees 24,41,92,237.40. Stop. Next, the learned counsel opinion for the petitioner, who should have done the calculation, depends on a calculation sheet handed up on behalf of the respondent award holder. Stop. The calculation sheet has been shared. The calculation sheet has been presented to the court and has been shared between counsel. Stop. Next. AP 671 of 2023. After hearing learned counsel, the impugned award dated 30th April 2018 is stayed subject to the petitioner/award debtor depositing rupees 10,15,89,526 by way of a cash deposit with the registrar original side by
4 weeks.
by 29th, by 28th September 2023. Stop. The remaining amount of rupees 14,26,2711 will be furnished by way of a bank guarantee from a reputed bank, which is a constituent of the Reserve Bank of India, within the same time frame, that is by 28th September 2023. Stop. Next, significantly, the arbitration petition, the section 34 application was filed on
the year 20.
My lord, 7 September 2018. May I hand
was filed on 7 September 2018. And the petitioner has not taken, petitioner/award debtor has not taken any steps for moving the said application or having it heard by any of the available benches, capital B, benches. Stop. The application for stay of the award has been filed 5 years after filing of the section 34. Filing of the section 34 application. Stop. Next, the award holder shall hence be at liberty of withdrawing the principal sum, which is to be deposited by way of a cash deposit of rupees 10,15,89,526 within 7 days from the date on which the said amount is put in by the petitioner award debtor. Stop. Next, AP 671 of 2023 is disposed of in terms of the above. No, yes, it is made clear. If the petitioner fails to comply with these directions, the respondent will be at liberty of executing the award from 29 September 2023 onwards. On and from 29 September 2023.
It's already pending, my application execution.
Very good. Yes.
My lord, and the point of maintainability, my lord, if your lordship kind
of what?
My lord, whether my lord, the section 34 application
Is the 34 in the list?
No, my lord.
Then how can I say that? Yes, next.
Grateful, my lord.
Item number 15, Sri Bimal Chandra Roy. Item number 15.
Dekhi. First day. No one appears for the petitioner. List this matter tomorrow. Next.
Item number 16, Universal.
My lord, for the respondent, my lord.
Microphone, please.
For
Yes.
This is an application under section 29A for extension of time to complete the arbitration proceeding. The arbitrator was appointed by the order dated 7th of April.
Not relevant. You just tell me when the pleadings were complete and start calculating from that date.
Yes, my lord, the
If you're not ready in the matter, take time.
but kindly adjourn this matter to
When do you want to come back?
tomorrow.
Tomorrow. Plus, but please read 29A, all right?
My lord,
May it be day after instead of tomorrow, my lord?
List this matter on 20th September 2023 as prayed for on behalf of both the parties. Next.
Item number 17, Mrs. Tim Corn.
But I am for the
Opposing this act.
I am for the petitioner. My lord. This section 29A.
I can't hear you. Microphone, please.
My lord,
Are you within time?
My lord, within time, my lord.
Within time, yes. When did the 1 year?
My lord, 1 year expired on my lord 28th February 20 March, my lord.
28th?
20th February 2023, my lord. And after extension of 6 months, my lord, it is 1st March 2023, 31st August 2025, 31st March 2023 to 31st August 2023, my lord. And my lord, I have filed this application on my lord 29th August of this 2023, my lord. And award was passed, my lord, on 31st August.
Not required. Award already passed.
Already passed, my lord, but after filing this application, my lord, it was noticed to us that
When was the award passed?
award was passed, my lord. It was due to pass on my lord 31st August, but it was not transmitted to us according to the mail of the learned arbitrator, my lord.
When was it passed?
It was passed, my lord. It was signed, my lord, on 31st August 2023, my lord, but it was transmitted to us, my lord, on 11th September 2020.
Yes, Mr. Mukherjee, why are you opposing?
But the award was it is predated. It was sent on 12th of September.
Predated. Show me a minutes, please. Don't have to announce the arbitrator's name in court. Just show me a minutes. I want to see the name. Very well. But what remains of the application, Mr. Mukherjee?
Now that it is.
Madam, only my lord, I'm seeking, my lord, it may be continuous since, my lord, I have filed this application before before publishing the award, my lord. Let it be continuous, my lord, so that, my lord.
What are you saying? This is an application for extension of the mandate. How can it continue? Award has been passed.
Award has been passed, my lord, but application was made before that. That is why, my lord, it is.
Yes, nothing remains of the present application, which is for extension of the arbitrator's mandate, after passing of the award on 31st August 2023.
The award doesn't contain the date. That is what I want.
After the award has already been passed, has already been delivered, been passed. Stop. Next, there is there is a controversy. Now, there appears to be a controversy on the date of making of the award, semicolon, while the both parties say that the award was made after 31st August 2023, which is the outer limit of the mandate of the arbitrator, but signed on 31st August 2020, but signed within the period of the mandate.
It is not signed, but it is not dated.
Not even signed.
No,
Then
it
what
is
is it?
signed but not dated. Signed but not dated.
Yes, but may have been signed within the period of the mandate. Stop. Next, AP 635 of 2020. No, such point can only be taken in the application for setting aside of the award. Stop. Next. AP 635 of 2023 is accordingly dismissed as having become infructuous.
Agreed.
Available side, please.
May I take back the minutes? Sir?
Yes, Minister Ferrotero.
Appellate side daily list. Item number 1 for judgment, Yazur Fiber Limited.
The factual conspectus presented by the parties in this application was not made available to the court on the day of passing of the order, that is on 18th October 2022. Considering the relevant law on the subject and the material disclosed before this court is of the view that the order dated 18th October 2022 should be recalled. Can 1 of 2022 is accordingly allowed and disposed of by recalling the order dated 18th October 2022, passed in CO 3262 of 2022. Needless to say, the parties shall be relegated to the position which they were in as on 17th October 2022 and be at liberty of taking steps in accordance with law.
My lord, may I pray for stay of operation of your lordship's order for a period of 7 days, my lord. We will file an appeal, my lord, and
Yes,
in an order of minutes.
considering the facts which were brought to the notice of the court after the ex parte order dated 18th October 2022, the prayer for stay is considered and refused.
My lord, may I be permitted to take back the book of Bengal Assam Agra?
I can't hear you.
May I be permitted to take back the book of Bengal?
Yes, yes, yes. Go ahead. Yes, yes, just take it back by 4:30. You will get it. Just send somebody. It's in my chamber. Sorry.
Deeply obeyed.
Lordship, the civil revision, my lord, will be heard afresh, my lord.
Clarifications, you have to go for the trial court. No further submissions. Next.
Item number 2.
Two and three, matter that has also, your lordship had heard this at length. The learned advocate general was appearing for the state.
Heard and forgotten.
Yeah, understandable, it's been a while. If your lordship desires, I can just. The notes have been filed, my lord's.
Actually, after reading your notes, I've forgotten the matter.
Then disregard his notes. Please go by mine.
But good to see you, Mr. Mukherjee, after a long time.
I'm grateful to lordships.
Yes, Mr. Banerjee, when will you come back with the matter and disabuse the court's mind?
Whenever. Your lordship would just require us to take your lordship to the notes or get into a slightly more detailed.
Start with the notes. If I find that everything's coming back to me, then.
But I could take that try for 2 minutes today. My
No,
assessment
not
of
today,
the
because
bench-
I have a division bench at 3:45. And my learned colleague will be waiting outside the court. Yes,
Whenever your lordship deems fit.
কবে হয় এগুলো? পাঠার সোমবার. Yes, the notes are before the court. Capital N, stop. Lists matter on 25th September 2023. Just take me through the notes,
Yes,
Mr. Banerjee and Mr. Mukherjee.
Can it be on 26?
I only take up these matters on Mondays.
Item number 3. Item number 3, same.
2, 3, same.
Yes.
Item number 4.
I'm for the petitioner led by London Senior Mr.
Go
Kishore
for the-
Datta. I'm for the petitioner.
You don't know where to stand in my court.
I'm for the petitioner lordship led by London Senior Kishore Datta lordship. Earlier occasion, we concluded our argument lordship and the respondent started their.
Mr. Datta has concluded. Yes, Mr. Jena.
Mr. Mitro was continuing his submission, my lord. I'm praying for.
Mr. Obrojit Mitra.
Obrojit. All right. Today, yes.
Yes, adjournment is paid for on behalf of counsel appearing for the respondent. Stop. List this matter. On 25 তারিখে কটা আছে? 25 তারিখ? Yes, on 9th October 2023. Next.
Item number 5.
My lord, same, my lord. 4 and 5.
Same order as paid for, no? Same order.
Item number 6.
I appear for the state.
For the state,
For the state.
I thought you were used to appear for the national.
My lord, I do that, but now, my lord, the state has reposed some trust.
Whoever hires you.
Yes, my lord, we do not have the luxury of picking and choosing, my lord, whoever has.
Yes.
But I appear on behalf of the petitioner, my lord.
So is the state's position different from the universities?
Possibly not, my lord. University. Same.
So you're also going to rely on the UGC guidelines.
Yes, that's one. But apart from that, my lord, other points, so far as the amendment is concerned, also, my lord, if your lordship permits.
So what will you say? The retirement age is what?
Retirement age should be 60, my lord, because he does not fall within the category of a teacher.
Should be 60.
It should be 60 because, my lord, the 62 and then
That's what the
subsequently
UGC says.
65. UGC, my lord, it is. But what I have understood from the matter is, though, my lord, I have come in really at the fag end of the matter. But what I've understood is, my lord, what I've understood of the matter is that the petitioner is claiming the status of a teacher. Now, my lord, so far as teachers are concerned, teachers initially was 60, subsequently by a state government notification, it was enhanced to 62 and thereafter 65. But, my lord, he is an accompanist. Now, my lord, there was an amendment in the act and accompanist was brought outside the purview of teacher and became a non-teaching staff.
Yes.
So, but there lies the dispute. So, my lord, I would be humbly submitting, my lord, because the amendment, my lord, they say is not retrospective. It's true, it is not retrospective because it is not specifically mentioned in the amendment. But, my lord, this type of, I would say that it's a curative amendment or a clarificatory amendment, my lord, it would have retroactive operation. So, my lord, I want to argue on that point. And apart from that, well, the service conditions also there is no vested right and well, it can change with time to time. That a line of judgments are also there on these 2 points. Well, I want to make my submission. But
And the petitioner is enjoying an order.
he
interim
is
order.
enjoying an order and
What
he
is
is
what is that
continuing his
interim
service.
order you're enjoying, Mr.
Interim order, my lord, has been placed that during pendency of this writ petition, lord petitioner can continue in the service.
He is continuing, he is getting his salary, he
No.
has all not getting salary. I'm sorry. then
Mr.
I'm-
Das. Mr. Das.
My lord,
Yes. So the petitioner is what? He is continuing in service.
he is regularly attending the university. He has not allowed to load the classes and no salary has been released. For the in contempt proceeding before the division bench, pursuant to the intervention by the AGs, the learned AG, the salary of the petitioner was released till November 2022. That is beyond 60 years. That is the 60 About 64 years.
No, so the petitioner is how old?
He's not the, today about not the 64 years.
64.
Yes, in January, not the, in January
But
2024.
Mr.
So this matter, not the, went up to Honorable Supreme Court. Up to
Mr.
period-
Chaturvedi was appearing.
Yes, yes, Lord. He was the, he is.
But Mr. Roy, what I don't understand, if there is an order of court and if the division bench has not set that order aside, then why would the salary not be
But
paid?
I'll tell you, Lordship, but what has happened is,
Because the writ petition may be dismissed because of what you will argue, but that's a different matter. But till the order is subsisting, why will the petitioner not get his salary?
but I'll tell you, Lordship, what has happened is, but there are two sets of litigations. But the petitioner filed a writ petition saying that I will be considered as a teacher and I should retire at 65. Now, Malad, in that writ petition, he was successful. The matter went up to the division bench upheld the order. Then there was a contempt proceedings and Malad, whatever has happened there has happened there. That's one aspect of the matter. But the findings of the court were that he is entitled to continue in service as per the government order, which extends it from 60 to 62 and 65. But there is no finding about the the amendment and whether he is to be treated as a teacher or not. Apropos the amendment. In the meantime, other writ petitions were filed. There, that also went up to the division bench. Now, there, the division bench
So
headed
talking
by
about the
my lord,
division bench of Justice Sen or Justice the
Sen's division bench is of the petitioner. It relates to the writ petition filed by the petitioner. Now, Justice Dotto's division bench, some other petition. There, an order was passed that the university has to decide. Now, the university decided. That order, is standing in the way. Now, that order is under challenge in this writ petition because, your lordship will consider if what my learned friends are saying is correct, that the matter has been, Justice Arindam Sinha was the single bench and thereafter the division bench presided over by my Lord Justice Showmention was the division bench. If that order stands, then there is no question. The matter ends there. What is the reason for the petitioner to file this writ petition? Because the issue has been decided already and it has reached finality. As my learned friend said, of course, it went up to Supreme Court. A review petition was also filed, but all were dismissed. But what happened is because of Justice Dotto's division bench, now this order came, which also the university said that no, they cannot be, the accompanies cannot be treated as teachers. Now, after that, that order was challenged in this writ petition and that order was challenged also in another writ petition. Now, in that writ petition, your lordship has set aside this order. The order which is under challenge in this writ petition. That has gone up to the division bench. Division bench has not stayed the order. Division bench has simply said that let that person continue in service subject to the result of the appeal.
So, but if a person continues in service, the person will continue without getting paid. What do you
But,
say?
for the
Without getting paid for
But
his
the
services.
payment part, why I was under the impression that in contempt payment has been made, but this issue has to be decided whether he is a teacher or not. But why he has not been paid, I have to take
Mr.
instruction.
Roy, you may take instructions, but I will pass an order that he has to be paid. Subject to the writ
Subject
petition
to-
doesn't
yes,
mean
yes,
that the
of course.
person will be rendering services and not get
No,
paid.
because Justice Showmen's order, the division bench order is, so far as that is concerned, I feel that it is clear on that issue. The finding is, the operative part is, all service benefits be disbursed considering the writ petitioner respondent as a teacher in terms of the definition clause of clause 22 of section 2 of the Act within a period of 8 weeks from date. Now, I understand that there was an application for contempt, but what happened in the contempt, I do not know. Division bench order is clear that he has to be paid. And this order is
Very
of
well, I will pass that order.
that 2020, now after 2020, what has happened, in that proceedings, I am.
Yes, so show me the division bench order with in appeal from my order.
Yes,
please.
My lord,
I have.
I am on
one
behalf of
copy.
the university, my lord.
Yes,
My senior arguing.
doesn't matter. I will pass an order, then you can challenge it. Yes. What affidavit? Not required. Yes.
It is annexed in my lord reply to the opposition filed by the respondent number 3 to 6
Yes,
at page, start from page 19.
starts from, don't disturb the court.
Page 24,
Page,
page 24 of my reply. Yes. Filed by the respondent number 3 to 6 in that contempt, in that matter of the opposition. Page 24, my lord. Second paragraph, my lord.
what is the page 25, Supreme Court order, what is that?
Supreme Court order, that is the SLP that has been dismissed. Then my lord page, then my lord's order in other proceeding. Then my lord, they have,
No, show me the page, Mr. Roy, where did,
Internal page 6 of the division bench order. Can you have a look, the last page? The last paragraph, last but one paragraph. All
Very good.
service
Yes,
benefits.
yes, I've seen.
But I do not know, Malad, if the university is represented, Malad, they can, because they have to pay.
my senior
So if this order is there and subsequently there was a contempt
Yes,
application.
who is
I
for
do
the
not-
university?
Madam is-
is online, Mr. Arunam Chakraborty, my lord.
Yes, have you complied with this order of the division bench?
No, division bench is partly order confirmed that the landed AG was asked by Justice Division Bench and payment was made through the government. Because as per UGC regulation, the latest judgment of the Honorable Appeals Court, UGC regulation is binding upon the university.
Mr. Chakraborty, don't go off on a tangent, please. Answer the court's question.
Let me submit my own way. If you don't want to hear me, you correct it.
Just answer the court's question. Have you
My question is, my answer is that they are not, because the government of West Bengal paid money to Mr. Ashish Mukherjee as per direction of the Honorable Division Bench. They have suppressed this fact.
Have you paid the petitioner till
Yes,
today?
yes, that we don't, because he filed an application before contempt application before division bench, and division bench ordered to pay, and that order was also challenged before whether in a contempt petition, but as the government already paid, that challenge is become infructuous because
Very well. So according to you, the petitioner has been paid in compliance with the division bench's order.
Yes, that it is a different proceeding. Division bench had complied because
Very well. Mute. Yes,
Just.
yes.
In division bench, my lord, I have prepared a list of dates. Herein I have annexed the
Is
last order.
according to the person who's appearing online says that the petitioner has been paid in compliance with division bench order. Is that correct or not?
Pursuant to the order dated 2nd December 2022.
Yes.
In November 2022 has been payment.
And
made.
after November 2022, how will the court know that?
My lord, that I only, my lord, I have stated. Because nothing has been paid, because that amount also paid pursuant to the, my lord, the intervention of the 100 GP. My lord, I have prepared a list of.
No,
dates.
no list of dates will be taken. Which is the first page of this order, Mr. Roy? 15 December 2020.
I do not, it is 15 December.
Yes.
15 December 2020. And according to the petitioner, he has been paid till November 2022. And how do you know that the payment has been stopped after 2022?
But that payment has been made pursuant to the order by the division bench in contempt proceeding. That order I have
Yes,
annexed.
show me the order, please. Where is the order?
Page 19.
Page 19.
Yes, 19.
2nd December 2022.
Yes, this is the.
And where does it say that you have to pay him?
Here at last portion, my lord, kindly see. But I am led by Mr. Chaturvedi. But I am led by Mr.
Yes, Mr. Chaturvedi, the order of the division bench, where does it say that you have to pay him?
Lord, kindly will not come to Lord, the internal page 22, internal page 4, page 22.
Yes.
The state of West Bengal Department of Higher Education shall make payment to the petitioner directly on account of arrears of salary emoluments as admissible and calculated till November 22 within a period of
till November 2022. Very well.
2022.
And after that, there was no direction.
After that, there was no-
Post November 2022, there was no direction.
No, because
Very
this was contempt application. So, my lord, this was confined until that date. But the fact, my lord, remains that the issue whether I am entitled.
No, Mr. Chaturvedi, I'm not on that. It was only on the limited question of whether the petitioner has been paid. So this direction, there is no extension post November 2022. Very well.
The contempt, my lord, to dispose of upon, my lord, giving, my lord, a caution.
Very well. Yes. The Mr. Roy, when will you come back with your arguments? Tell me.
Could it be the week after next
Microphone,
Monday?
please.
Your lordship takes up these matters on Monday. Could it be Monday week? Well, next Monday I have some personal week.
And what do you want to file for UGC? I can't hear you.
Microphone to me. Behalf of the University Grant Commission. I have prepared on the last occasion. also
No, what
tried
is this affidavit you want to file?
Affidavit, my lord, kindly see this affidavit. Kindly see this affidavit, my lord.
What is the affidavit for? Is there a direction
Affidavit-
on you to file?
Affidavit opposition containing the only two paragraphs, kindly see, my lord. On the last occasion, my
Can't you
lord.
understand the court's question? Is it something pursuant to direction? Were you under direction to
Yes.
file? Say that, yes or no?
Yes. Paragraph 6 and 7.
What is the date of the direction?
I do not remember one. Lord.
Do you want to file a reply to this, Mr. Chaturvedi?
Lord, yes. my lord.
You have filed or you will file?
I-
And what about you, Mr. Roy?
But I have filed my.
You have filed?
But I don't know, it is in your lordship record, as it were.
দেখো stated affidavit of opposition আছে কিনা?
We have not filed a reply to the state's affidavit in opposition.
I have a copy of it. Statement respondent number 1 and
And the university has also given the opposition?
Yes, to which we have used a reply.
Very well. What is the date, the direction on UGC to file?
UGC, my lord, the direction is not there, but 10th March 2022, my lord passed an order calling for affidavits.
10th March 2022.
My-
And UGC is filing today.
Oh, a specific direction not upon me, my lord, but direction was there, that's why I am fighting.
Yes, show me the order, please, Mr. Chaturvedi.
My lord, 10th March 2022, my lord, the last 5 lines, starting with the words, the affidavit in opposition be filed. The affidavit in opposition be filed within 3 days by the respondent university as prayed for. The state will file its affidavit in opposition within 10 days. Reply hereto, if any, be filed within a week after the affidavit filed by the state. The petitioner shall make UGC as a party to the petition. This
Yes, and when did you make the UGC a party?
same day.
Same day, that is 10th March 2022.
Right.
Very well. The University Grants Commission has filed its opposition today in court. The opposition was affirmed on 17 July 2023. It appears from records that the respondents were given liberty of filing affidavits on 10th March, filing affidavits by an order dated 10th March 2022. The petitioner was also directed to add the UGC as a party to the writ petition. This was done on the same day. Next. The UGC has filed its opposition, hence after 16 months. The UGC shall accordingly pay costs of rupees blank to blank within 7 days from date. The affidavit in opposition is taken on record. Next. The petitioner seeks to file a reply to UGC's affidavit in opposition. The reply shall be filed within
7 days.
7 days from today. List this matter on Mr. Roy. When will you argue? Sure. Council ওখানে একটা ক্যালেন্ডার রাখবে কালকে থেকে। Yes, when? Either 25th or 9th. Mr. Roy? 9th. Learned counsel appearing for the state, comma, who has been recently engaged in the matter, comma, will make his arguments on 9th October 2023. Stop. List this matter on that date as prayed for. Stop. Next. The initial controversy with regard to whether the petitioner is entitled to be paid for his services, for the services rendered to the university, is laid, LAID, laid at rest. Appears to have been laid at rest by the order of a division bench of this court in a contempt proceedings, which directed the state to pay the petitioner till November 2022. Stop. This apparently has been done. Stop. This apparently has been done. Stop. Next. You did not ask for extension.
So the extension, not the scope was only
Very
that
good,
I am
very
entitled to 60 to 62 years.
Yes, yes.
So for that period, my lord, I have been paid. I could not have enlarged the scope of that.
Very good. Thank you. Yes, call on the next.
20th May, there was in 2022, there was a direction on me to file my written notes of arguments along with the decisions.
Not today, Mr. Chaturvedi. Let me hear, because you may want to file an addition to it after hearing Mr. Roy.
Yes.
So why would you want to?
Yes,
Yes,
foreclose.
just wait for that. Please. Yes, next.
Item number 7.
I was addressing your lordship.
Mr. Paul, will you move the microphone, please, so that I can see you?
Yes.
If I can't see you, then I can't hear you. So you will be at a disadvantage.
I'm sorry. But first of all, Lord, may I just summarize what I submitted on the last day in just 5 minutes. Lord, the writ petitioner, Lord, had approached Axis Bank for grant of a loan. Now, Lord, there was a contract entered into between Axis Bank and the writ petitioner, which had a clause that the Axis Bank might, Lord, assign a part of the claim in favor of other bank, part of the loan in favor of the other bank. Now, Lord, Bank of Baroda was approached and there was a sanction which was granted by the Bank of Baroda, which was granted on 30th of March 2015. Now, Lord, shortly put, that sanction letter contained, Lord, the base rate of interest at 11.75% and, Lord, delay payment, delay in making payment at 2% and penal interest, Lord, 2%. Now, Lord, this original sanction letter did not have any default, Lord, with regard to the security clause. Now, no penal interest or no interest was charged for default in giving security, because, Lord, it was agreed that whatever security is there will be, Lord, shared pari passu by the bank. Now, Lord, subsequently, Syndicate Bank also, Lord, joined the loan. Now, ultimately, Lord, it appears when we reached 2019, that, Lord, a staggering figure was outstanding. And, Lord, the petitioner, Lord, himself, Lord, had offered in 2016, when, Lord, part of the loan fell due, repayment fell due, he had offered to grant additional security. I had taken your lordships through these documents. Now, Lord, in 2019, when the contract was reviewed, there was a huge outstanding in the account of the writ petitioner. So, Lord, what was agreed was that, Lord, 14.15% would be the rate of interest charged. This 14.5% included a 2% on account of default in creating security, additional security in favor of the bank. So, Lord, 14.15%, including 2% in default in, Lord, creating security in favor of the bank, Lord, and it was also, Lord, mentioned therein that, Lord, in case the security is perfected, then, Lord, the interest rate will go down to 12.15%. Subsequently, Lord, it was also, Lord, agreed that the spread will be penal interest will be 1%, delay in payment will be charged at 2%, and Lord, any default in so far as carrying out the other Lord, terms and conditions of the contract will be charged at 1% at the penal rate. This was Lord, the agreement in 2019. Lord, if your lordships kindly Lord, come to page 295 once, your lordships will find that Lord, this was the this is the agreement which was entered into in 2019. Now, Lord, this agreement Lord, remained between the parties till the writ petition was filed. In between, what had happened is they had submitted Lord, a proposal for reconstruction of the loan. Lord, your lordships, I would request your lordships to kindly Lord have a look at
Yes.
this document, which is Lord at page the structuring of the proposal. Yes, page 316. Yes, it is second volume I have.
P16.
Yes, Lord.
Yes.
If your lordship straight away come to page 320. Lord, kindly Lord, see the restructuring proposal, which is Lord at the bottom of the page. Lord, there is a table. Lord, kindly
Yes.
take the second serial number. Principal and interest moratorium requested.
Mr. Kaur, just 1 minute, please. 320 is a document of IQ City.
Yes, Lord.
That is Mr. Chidambaram's, the petitioner.
Petition.
And this is a restructuring proposal.
Proposal. The document starts at page 316.
Yes, yes, I have it.
Now, Lord, kindly see the table. This was Lord given in 2020.
Where do I get that from?
The date is at the top Lord left-hand corner, 14th of January, 2020. Page 316 has your lordship.
Yes, yes, 14 January. Yes.
Now, Lord, please come to page 320.
Yes, yes, I have it.
Kindly see, Lord, the second serial number. Principal and interest moratorium requested. Principal outstanding, 194.25 crores. Interest overdue, 7.11 crores. Total restructured amount, 201.36 crores. As on 29th of February, 2020.
Yes.
Interest on principal term loan during the moratorium period, 2 years, 1 month shall be capitalized in FITL account along with etc. Now, Lord, this proposal was not accepted by the bank.
You did not accept it?
No, it was not accepted. The bank, Lord, rejected this. But what I wanted to show from this document is, as on this day, the 29th of February 2020, it was calculated, Lord, up to 29th of February, the outstanding admitted is not contained in this table. Your lordships will find that these are the figures.
So the outstanding is 201.36 crores?
Yes.
As on 29 February?
Yes.
And what turns on this, Mr. Kaur?
The fact is, first, Lord, the security was not perfected. So, Lord, interest continued at 14.15%. Secondly, Lord, default, which Lord entailed 2% interest, that also continued. Lord, from these documents, your lordship it will appear that in 2020 and up to the date of filing of the writ petition, this default continued. Therefore, Lord, 2% was charged for default in payment of installment. And Lord, 1% was charged because, Lord, under the contract, it was agreed between the parties that in case his credit rating goes down, then Lord, that will be.
Yes, that part I remember. You mentioned it last. Yes.
So, Lord, the overall issue is 17.15%, which was charged. These rates are contractually agreed rate. There was nothing, Lord, extraordinary, or Lord, no interest rate was charged, which has not been agreed between the parties. Lord, this happened, Lord, in 2020. After this, your lordships may kindly come to not just 1 or 2 documents. Lord, kindly, Lord, see the letter of the bank, which, where, Lord, the bank.
Mr.
says-
Kaur, you have to use the microphone, please.
Lord, I'm sorry.
Yes.
Lord, first, kindly not come to, no, bank explaining that why they are charging 7%. Just, please, before that, there is a letter they are asking. Lord, please come to. Kindly give me water. This 309. Page 309. Kindly, Lord, come to page 309.
Yes. Your letter to the petitioner,
Yes. On 30th of November,
non-perfection of security.
yes. Non-perfection of security, Lord, continued till the date that writ petition was filed. And even today, they have not. But Lord, in the meantime, the loan account has been paid. The outstanding loan amount has been paid. Therefore, Lord, the bank has given them an offer of reduced rate of interest. But they are not accepting that. They are saying that you will have to give it retrospective, even for the period when the loan account remained a default account. And Lord, the imperfection of security continued. So Lord, this is basically, Lord, the dispute between the parties. And Lord, so far as the charging of interest of 7.15% is concerned, that was charged for the period. The amount remained in default and imperfection of security. And of course, Lord, the credit rating having gone down. These are the three heads on which the charges were made. Now, your lordships may kindly page 309. I was referring to page 309. It clearly says that we refer to a sanction letter, inter-credit rating of your account based on such and such, degraded from BOB's FR3 CR4 to BOB's 7 FR CR7. So, Lord, 4 to 7, this was the degradation. And your account also attract penal interest 2% due to non-perfection of security. Hence, applicable rate of interest increased to 17.15% per annum in your account. And Lord, this situation, on paper, we can show that it continued till the writ petition was filed.
That the non-perfection of security.
Non-perfection of security, Lord, entailed 2% extra.
Yes.
That came to 14.15%. Then, Lord, default continued. That restructuring proposal of 2021 admits that there was a default. And there are other minutes also. I don't want to trouble your lordship because of paucity of time. There are other documents also, minutes where, Lord, they admit unequivocally that we are in default. And that is the reason why they had given that restructuring proposal. So, Lord, 2% on that, and Lord, downgrading of credit rating, that was 1%.
So three factors.
Three factors. Well, one factor was, Lord, built in the 2019 Lord review meeting when, Lord, it was agreed that 14.15% will be charged, which included 2% security imperfection. And Lord, the other two items, namely default, attracted 2% and 1% for downgrading of the credit rating. This is, Lord, the situation. And Lord, when the loan was granted, Lord, it was not contemplated that the party will default. And as a result, the risk will go up. Otherwise, Lord, the security which we had was sufficient as on the date of grant of loan. And Lord, we had agreed that the banks will share it pari passu.
Yes.
But Lord, when the risk went up, then Lord, they themselves came up and they offered, they agreed. And I have shown that letter that they agreed that we will give you the security. And that's how, Lord, the security became a part of the contract, that they will have to create this additional security of 90 odd flats, which they did not. And I'll show from the document that they in fact sold part of those flats without obtaining NOC from the bank. Now, Lord, this is the whole conspectus. I will take your lordships through, Lord, 2 or 3 paragraphs of my affidavit in opposition, which clearly says how much the rate that was charged and for which period.
So you charge 16 point something.
17.15% for the highest default. For the highest default. It's not
So
that
there was a gradation.
gradation in the sense, Lord, in between,
Yes.
there were some, Lord, loan sanction for the purpose of repayment during COVID time and all. So, my lord, that's the time when there was a lesser interest charge. I've given a chart also, my lord, in my affidavit to show, my lord, what rate was charged at during what period. That is there, my lord. I'll take your lordships through that. And my lord, the other part of the argument would be that none of the Reserve Bank circulars, my lord, on which my learned friend has relied,
Yes.
has any application in the facts of the case. It will appear from the Reserve Bank circulars itself.
Yes.
And the only circular which will govern is the circular which I have annexed to my affidavit in opposition.
Why do you say that they will not apply? or
Because
they are
Lord,
not
it
relevant?
clearly says in the circular itself
Yes.
that insofar as the consortium loan is concerned, those circulars will not apply. Those clauses don't apply. I'll crave leave to, Lord, there are two circulars on which Mr. Chidambaram has relied. There is given in a separate compilation. I'll rely on those. And Lord, I have relied upon a circular which is there annexed to my affidavit.
That is the only one according to you which is relevant?
Yes. And that says that even in a consortium loan, a bank can have different rate of interest.
Very good. Mr. Kaul, you have to come back on a Monday.
Lord,
Will it be 25th or 9th?
25th, Lord, we are ready so far this matter is concerned. Better that I finish it.
Next matter, item number 8.
You have to wait, Mr. Banerjee.
I thought you must ask me.
I looked at you because you suddenly came into the shoes of the petitioner. That's why. Yes. Learned counsel appearing for the respondent bank will continue with the submission on 25th September 2023. Chidambaram, 25th.
Very well, my lord. I'll be in an arbitration, but I'll try to join virtually.
Very well.
Item number 8.
For the petitioner had a word with Mr. Kormakar. He has no other notes to file.
Mr. Chatterjee, I can see him on the online mode.
Oh, I'll just file my short notes on facts, my lord, now. Calls them clarificatory facts also.
So the clarification is
of my own
longer than the.
These of my own notes.
But I remember, Milord, that one page thing there. I mean, it's gone beyond that, so I don't know.
Yes, learned counsel appearing for the petitioner has handed up clarificatory note as requested by the order dated 13 September 2023. Stop. এটা কি CAV হয়নি এখনো?
No.
Yes, list this matter on 28 September 2023 under the heading for judgment.
Great.
Grateful, Judge.
Sorry, not 28th, 29th. 29th. That's a Friday.
Grateful, Judge.
বইটা তো criminal procedure তো দাও।
My lord, I am appearing for the state.
Yes. ডাকো ডাকো।
Circuit bench matter, item number 1.
Yes, I am for the state, my lord.
Yes, Mr. Chaudhary, we had kept this matter, whichever the last time was, for a clarification. And Mr. Doctor,
lord.
Mr. Basu, thank you. Mr. Basu,
389-1.
yes, 389-1.
Your Lordship, if your Lordship wants to give them the opportunity to file a written objection, that can be done. But right from the beginning, till today, Lord, they never prayed for any liberty from the court to file an objection with regard to the suspension of sentence. Your Lordship, keep the record straight.
Mr. Basu, microphone, please. Yes.
To keep the record straight, if your Lordship wants to give them a opportunity of
So,
filing.
Mr. Basu, because I was looking at 389-1. And you know, the whichever way we decide, that will become vulnerable because of non-perfection of
That's
the
what I'm
procedure.
saying. Lord, right
Yes.
from the beginning, they never prayed for this. But Lord, to keep the record straight and to comply with the requirement of law, if your Lordship wants to give them the opportunity of file written objection, but you can do that.
And showing cause in writing, that was a problem.
True. Let them show cause. Right from the beginning, Lord, they never paid for it. But Lord, to keep the record
Lord,
straight.
we will file our written objections.
File it.
Mr. Chaudhary, and within how much time?
My lord, let the matter be in the first week of October, my lord. By then we'll complete, we'll file it before your lordship and let the matter be disposed of.
But this matter was heard in the circuit bench.
Repeatedly, at least for 5 or 6 times. Five.
Order filed.
Yes, my lord, it was hard. But my lord, liberty is required, my lord, your lordship's liberty is required for filing a show cause in writing.
Should have asked for it. It was heard in circuit bench.
Did a hearing. Or a paper.
Yes, on 18th August 2023.
My lord, my lord, my lord.
Yes.
It was hard, my lord. Yes. But at that point in time, my lord, liberty was not there, my lord. So we are praying for a liberty.
Learned counsel appearing for the petitioners / appellants submits that an opportunity may be given to the public prosecutor, capitals, for showing cause in compliance with section in compliance with the proviso to section 389 within brackets 1 of the CRPC. Stop. Next. Learned counsel appearing for the PP, who is present on the virtual mode, seeks to file the written objection by the first week of October. Stop. Next. The records show that the matter was heard in circuit from 18th August 2023 till 25th August 2023. For at least 4 days. Stop. It is therefore significant that the public prosecutor or counsel representing the public prosecutor did not seek any leave of the court to file their written objection or show cause in writing under the proviso to section 389 within brackets 1. Stop. Next. Hence, this court is not inclined to give them any time to do so beyond 29 September 2023. Stop. Lysis matter on 6th October 2023. Stop. A copy of the written objection must be made available to the petitioner, to the advocate on record of the petitioners by 30th September 2023.
Grateful, man. I've given my appearance in the chat.